Great. Good morning, everyone. Today is March 14, 2025. This is our third meeting of the year, I believe, for the Committee of Bar Examiners. Devin, can you uh, call roll for us, please?
Dr. Bolton,
Oh, excuse me. Taking roll call.
Yes.
Here.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Kareem Gangora, Larry Kaplan,
Yes.
Alex Lawrence,
Here.
Esther Lynn, Justice Macy-Walla,
Here.
Bethany Peak, Ashley Silva Guzman,
Here.
Judge Reyna,
Here.
Vince Reyes,
Here.
Alan Yokelson. We have a quorum.
And Paul Kramer.
Paul Kramer.
Here.
Thank you. Before we call for public comment, I want to remind the public that under the Bagley-Keene Open Meeting Act, public comments must pertain to items that are on the agenda for today or be related to matters that are within the purview or jurisdiction of the CBE. Specifically, we, the CBE, exercise oversight on admission matters, including the California bar exam, the first-year law students exam, more character applications, and law school regulation. Also, we have just skimming through the agenda today. We have a full agenda. And as the chair, I reserve the right to limit each speaker's time to 2 minutes or to close the public comment period after 2 hours, which includes a 10-minute break or after the first 100 speakers, whichever occurs first. Now, please note that the staff will also have an on-screen countdown timer visible to all the attendees during the duration of your public comments. The timer's 2-minute countdown will begin as soon as you start your comments. The timer will flash throughout this final 10 seconds. To facilitate hearing as many members of the public as possible, I highly encourage you not to repeat points that were made by previous speakers to the extent possible. But also members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have enough time to consider those comments. The committee has received those comments and we have read through them. So thank you very much for submitting those comments in advance. Now, for those of you who are participating not in person, but via Zoom video, you should also have a function for virtually raising your hand. It's a little hand icon at the very bottom. It should appear towards the center of the screen. Now, if you wish to make a public comment, please click on that the hand icon. And also for those of you who are not appearing virtually through Zoom, but by phone, you may also raise your hand by pressing *9. That's the star key followed by the number 9. Also, please note that the public comments is limited to the public comment period. Should you wish to provide any comment, please do so during this time. Finally, for the committee, please be reminded that we will transition to the closed session for 30 minutes following the public comment period. And finally, before we open up the floor for public comment, I just want to take a quick moment as the chair to acknowledge the significant challenges our applicants have faced over the past several weeks, recognizing that the legislature and the Board of Trustees have both ordered their own independent investigation. And as part of this process, the CBE wants to hear from our applicants, those who had experienced major issues, as well as those who did not. Now, this is the time where you get to tell us what happened and what worked and what didn't work for you. This is, after all, a public forum, and so you sharing your experience, good and bad, is welcome and indeed encouraged. Unfortunately, I have learned that certain applicants who had commented on their positive experience about the recent bar exam were subject to ridicule and disrespect and even threats of violence after speaking at the March 5th Board of Trustees meeting. Some of their names were also posted on blogs and also on social media website that were belittled and trolled. And I also have learned that there have been personal attacks against members of our esteemed Board of Trustees and our staff as well. And in no certain uncertain terms, I want to say this type of behavior is not acceptable. It is neither condoned nor tolerated by this committee. It is also counterproductive to what we do here. And as chair, I empathize with our applicants and will make every effort to find out what happened. However, silencing those people or applicants with different perspectives or sowing chaos will not help advance any meaningful cause here. And the CB is committed to ensuring that every public commenter has the opportunity to speak freely without retribution, retaliation, or intimidation. So I encourage our applicants, the legal community, to remain vigilant and report anyone who may have threatened anyone about speaking freely to the state bar, including this committee. So with that, let me turn it over to our coordinator, Devin, who will now call members of the public in the order in which we received the comments, starting with those with advanced signups, followed by those participating through a noticed location, and then those with virtual hands raised. Devin?
Our first public comment will be from Benjamin Cohn, who's been allotted 3 minutes.
Thank you. I don't want to repeat all of the issues that were described in other comments and written comment about what happened. I want to get to remedies. So I want to first address that there needs to be a very strong emphasis on remedying the safety concerns with the California bar exam that arose this time and in past times relating to in-person testing. At least one commenter at the March 5 meeting blamed that they had a miscarriage due to the conditions by imposed on them by measure, and that was in the in-person testing. I want to remind you of the Cow Palace testing conditions, where some testing accommodation applicants were forced to test in a barn, swarmed by bees, denied their EpiPen. Then there are huge COVID safety issues relating to in-person testing, especially for those with certain disabilities. I understand that the California Supreme Court has directed that the standard condition of the July 2025 bar exam be in person, or at least that you plan for that pending further directive. But the issues with remote testing were caused because it was Measure. Measure botched the in-person testing and they botched the remote testing. There are other vendors that could do remote testing. It's being unfairly blamed for the issues that Measure caused across both modalities. And even if the California Supreme Court makes you do a standard condition for July 2025, for subsequent exam cycles, you should work on developing a reliable remote testing and not give up on it because of the myriad of disability accessibility, safety, travel cost sparing, state bar cost sparing, logistical, and other benefits. And even for July 2025, the state bar, freed from the NCBE's restrictions with the Kaplan rules, should still offer, consistent with the California Supreme Court's directive as to standard conditions, remote testing as a testing accommodation as it is required to do. Beyond that, rather than demurring for February 2025 that the fair remedies are beyond the state bar's jurisdiction, the state bar should make clear its recommendations for those remedies and publicly and promptly petition the California Supreme Court to provide those remedies, actively communicating with applicants and stakeholders on the status of the petition and ETA on the ruling from the court, and the financial costs of remediating Measure's failures and compensating this cohort of applicants should not be passed on to future cohorts of applicants through higher exam fees. The state bar should take legal action against Measure to recover damages. The makeup exam was also totally under-inclusive. Thank you.
Thank you, Mr. Cohn. Appreciate your comments.
All additional public commenters will be allotted 2 minutes. Our next public comment is from Haley Sinfield, who I do not see in attendance. Our next public comment is from True Cone, who I also do not see in attendance. Our next public comment is from Carla, who I do see. Your microphone has been unmuted.
Hi, good morning. Can you hear me?
Yes, good morning.
Hi, good morning. The bar exam is hard and not everyone should pass. The reasonable solution here would be a significant decrease in the cut score and to grade the totality of the applicant's submission, including notes, as we can't be sure the issues that we wrote about in the notes section transferred appropriately to our final upload. So although my written portion was uploaded successfully because we had such a small area to work with in the copy paste function, throughout the exam, some things copied twice or overwrote an issue that I already talked about. So in grading the totality of the submission, I think would be helpful to those of us whose submissions were uploaded, but it may not be what we intended to upload. As far as moving forward, California has the lowest pass rate in the country with no reciprocity. The last cut score reduction resulted in the February 24 bar, and second reads are used to fail more applicants. In July 24, my second read dropped by 25 raw points from the first read. 41 states in the US participate in the UBE and they're not bankrupt. So why does California refuse to use what's working for 41 other states? Each state determines their cut score and can require additional state-specific testing. Again, the bar exam should be hard to protect the public, but many of us have job offers and lives that are on hold for 6 months to a year at a time. Who protects the good applicants from the bar? Thank you.
Thank you, Carla.
Our next public comment is from Eugene Stevens.
Hi, do you hear me?
We can, thank you.
Yes, hi. First of all, I want to say that State Bar has completely frustrated reliable grading and may not fairly prove that we failed exam. Second, we reject your psychometrics because it is you who failed exam, not us. Third, the only feasible way under the circumstances to remedy such extreme prejudice is to issue 1. Full license to all attorneys already licensed elsewhere. 2. All repeaters with score 1300 or more on any prior exam. And provisional license to all other applicants without necessity of another exam. This is the only remedy which will bring peace to all broken hearts and restore justice for all. Thank you.
Thank you, Eugene.
Our next public comment is from Katie Moran.
Good morning. My name is Katie Moran. I'm an associate professor at USF School of Law. I'm here today making a joint statement with 7 fellow bar prep professors across the state. Our goal is to help the CBE ensure the integrity of the test, first by identifying weaknesses with Kaplan's multiple choice questions in terms of coverage, the questions themselves, and their overall validity. And this is especially important because the bar cannot repeat these mistakes by using these inferior questions that have not been properly vetted and analyzed for the July exam. Then our group will turn to discuss suggested remedies for February examinees on the multiple choice and finally the written portion of the exam to improve fairness for disadvantaged February bar takers. I am one of the professors who was mentioned in this morning's Recorder article that was disqualified from reviewing the February exam questions. And what I'm going to ask now, Devin, if you're open to it, is to turn to Dean Mary Basic, who also signed up in advance of the meeting to provide our first point.
Mary Basic did sign up, but we need to go in the order of those who signed up in advance.
Understood. Then the first point will be picked up by the first person who's called in order.
Thank you. Our next public comment will be from Jessica Jacobs, who I do not see has raised their hand. Our next public comment is from Mitzi, who I believe has their hand raised.
Good morning. First of all, I also reject the psychometrics proposal. I think everyone that's attended school for 4 years and spent hundreds of thousands of dollars should be fully licensed, even if it's provisional under supervision without having to retake the bar exam. Now, I'm going to specifically address page 5 and 6 of the agenda packet. The faster grading turnaround was requested to assess the full extent of the bar's failure in selecting a provider for the February exam, not to rush the grading and make it easier for students to fail. This proposal is not reasonable or a fair solution, nor is it in the spirit of what Dr. Tony and the board requested. And the reason I'm mentioning this is because the bar is now proposing to eliminate phase 2 and 3 or narrow that grading so we can have a faster turnaround. And that's not the spirit of this. The intent was, can we get more resources and get more help so we can analyze the extent of the damage and see what the remedies could be proposed. But I think we're past that because the bar seems intent on ignoring our requests or the inability to get the Supreme Court involved, and they keep pushing for psychometrics instead of taking accountability. And so now, if the bar truly believes in accountability, where are the resignations for people that failed us? Everyone still has jobs while we're all suffering and having anxiety about our future incomes and futures and how we're going to make ends meet and provide for our families. Thank you.
Thank you.
Our next public comment is from Ray Hayden.
Thanks. I hope you can hear me. I just donated blood and we were on our way home and I was doing a mobile Zoom call. So that was a hoot and a half. Let's get into it. I sent in information. I don't know if the CBE got it, but it was basically on a different alternative program to the admission process. You already have one of these in line. Mine is like pumped up on steroids and hardcore basic training kind of stuff. The training program for new attorneys is kind of what I'm talking about, but that's a 1-year program of mandatory legal educational courses that every new attorney has to do in the first year. Mine, you got 8 to 12 weeks, and that's negotiable, but it's got to require motivation, dedication, and raw determination, and it's got to be pretty kind of hard. But the MCLEs that new attorneys get is to stay out of trouble, which is protection of the general public. Mine includes a whole lot more because, like anybody, any real professional, when I get out in the world, I want to study and be all prepped up on what I need to know to hit the job running. I don't want to have to stop and slow down. And for 30 years, I've been listening to partners, law firm owners, and others. All my clients are attorneys, and I've been listening to them complain for 30 years that they get a newbie in. They got to spend all this money and time and effort to get them all trained up to speed, and they leave. Then they got to do it all over again. So I know what these people who are probably retired by now, actually some of them are not, but the fact of the matter is I submitted this program. You have it. It's there. You have it. Okay. And I need you to look at that. Prove me wrong. Prove me wrong. Look at it and say, this will never work. And then ask me questions on it, and I'll show you how it works. I created this program over 20 years ago. It's still in use today, and I haven't had anything to do with it because it's powerful, it's flexible, and it works. And you save millions and millions of dollars, and I charge nothing for it, okay? Just keep that in mind. Check it out. Look around for it at CalBar. You have the program. I sent it to you Wednesday, okay? So with that, I agree with everything Benjamin Cohn said. Thank you.
Thank you, Mr. Hayden.
Our next public comment will be from Jessica Jacobs under the name Jessica Ditch.
As you know, in December, this committee denied me credit for 3 completed law office program study sessions on the basis that I did not notify the State Bar of a change in supervising attorneys. However, I've since learned that this decision was made with inaccurate information presented by the committee to the committee by the State Bar Admission Office. The reality is that the bar staff themselves prevented me from submitting my study sessions, accurately telling me I could not submit them until my prior sessions were credited. And as soon as that occurred, 16 months late due to admission staff turnover, I submitted the new ones. Had my original sessions been addressed by the bar when they should have been in December 2022, I would have submitted my next session in April 2023, and it probably would have been denied because it had an unapproved supervisor's signature. But at that time, I would have been told about the hard to find and conflicting procedure and paid the $800 fee to make that change. That's easily and obviously would have and should have been caught back in April of 2023 so that I would have plenty of time to submit all 5 remaining sessions in time to sit for the July 2025 bar exam. Instead, I'm being punished and harmed financially because of errors and deficiencies on the part of the State Bar. But even with this new information and clarification, admission staff had refused to let me bring this matter back to the CBE. As such, I filed a Supreme Court petition for review, and as a taxpayer, I find it unacceptable that resources are being wasted litigating an issue that could easily be remedied with a simple and justified reconsideration by this committee, and it's surprising that there is no means to do so. Separate from my own issue, however, through my research, it's become apparent that the Law Office Study Program is failing its participants since there's no accountability for its success or implementation. I've made multiple public records requests for basic data on Law Office Study Program outcomes, and the repeated response is, we don't have that information. The Law Office Study Program requires evaluation, oversight, and clear communication protocols. The proposed changes on today's agenda do not fully address the deficiencies. The CBE should appoint dedicated staff members to manage this program and a directive to reply to participants at least within 30 days. And furthermore, the CBE should grant leniency to Law Office Study Program participants who were negatively impacted by the bar's unclear policies and lack of communication in 2023. The CBE should refund the $880.
Thank you for your public comment.
Thank you, Jessica.
Our next public comment is from Anne Camacho, who is with Suzanne Fryer.
Hello, my name is Anne Camacho. I'm an assistant professor at Pepperdine Caruso School of Law, and I'm continuing with part 1, I guess, of the joint statement of bar prep professors. As Katie mentioned, we are commenting to offer some practical suggestions to ameliorate any unfairness in grading resulting from the administration's failures and to prevent any repeat of this issue on the July 2025 bar exam, starting with addressing Kaplan's 200 multiple choice questions on the February 2025 bar exam. Kaplan has unilaterally expanded the subjects eligible for testing, under Business and Professions Code Section 6046.6. The Office of Admissions stated that the format, to quote, that the format and content of the exam will not change, and the new questions will be equivalent to the current questions as far as their alignment with any content areas, writing style, and validity for assessing minimum competency. Any modification of the exam for content and format would trigger the 2-year rule. However, Kaplan's multiple choice question content map exceeds the content covered on the NCBE MBE subject matter outline and any previously released MBE questions. The Kaplan content map has unilaterally added at least 34 new areas that are now eligible for testing, as detailed in the public comment that it was submitted by Mary Basic. Secondly, Kaplan's sample multiple choice questions have errors and cover topics that are not eligible for testing. The faculty and student guides were originally distributed in fall 2024, and a revised redline version of the student guide was released on February 6, 2025. 6 of the 25 questions still have significant problems. 4 questions test concepts not on Kaplan's content map or the NCBE subject matter outline and have never been the subject of a released MBE question. 1 question has no correct answer choice because the law is wrong, and 1 question has 2 correct answers because the question is poorly drafted. If this 25
Thank you for your public comment.
Thank you.
The next public comment is from Candela, who I do not see in attendance. Our next public comment is from someone with the initials TS, who I also do not see in attendance. Our next public comment is from Marcus Friedman,
Good morning, committee members. My name is Marcus Friedman, Administrative Director for the Consumer Protection Policy Center, or CPPC, at the University of San Diego School of Law. CPPC is a nonprofit, nonpartisan academic and advocacy center at USD School of Law. We've examined and critiqued California's regulatory agencies for over 40 years. The February 2025 bar exam resulted in 238 test takers that were unable to complete the exam session. Further, there were 1,500 test takers that were registered for the February exam that decided not to take the exam after the State Bar offered refunds in the middle of February. On March 4th, the Supreme Court of California directed the State Bar to administer the July bar exam in person, which will undoubtedly drive up testing costs for the agency. Both the number of incomplete test takers and the increased costs imposed on the State Bar are extreme concerns. However, there is a solution that can assist those affected by the February exam and help the agency save on budget costs, specifically the portfolio bar exam. On October 10th, 2024, the Supreme Court of California declined to adopt the PBE due to concerns over current law, fairness, and overall competency. Although the court's reasons to decline the PBE at the time were valid, CPPC believes that this is the right time to address those concerns and offer an alternative pathway to licensure for those affected by the bar examination. First, to address the issue with current law, CPPC has drafted emergency legislation that would allow the State Bar to utilize the PBE up until July 1st, 2027. The legislation would give authority to the State Bar to license applicants and test minimum competency to practice law in specific practice areas. Second, the State Bar would need to continue its work on the PBE from late last year in the creation of the PBE committee. To address fairness and consistency in test competency, the State Bar would need to evaluate different practice areas to evaluate, such as litigation and transactional practices. While this solution will not be readily available for all applicants, it will ease the general stress and frustration for those applicants that do have post-bar work or attorney jobs waiting for them after the February bar exam results. We appreciate the State Bar and the Committee of Bar Examiners' consideration for this proposal. Thank you.
Thank you, Mr. Friedman.
Next public comment is from Farida.
Hi, good morning. My name is Farida Beg. As a hand writer for the February 2025 bar exam, I want to express my frustration and anxiety leading up to the bar exam and which carried into the exam itself. I was originally supposed to take the exam in Long Beach, which would have been good because I live there. Instead of spending quality time studying for the most difficult bar exam in the country, I spent numerous hours reviewing and responding to emails that my location changed from Long Beach to Ontario, then to Walnut, then back to Ontario, and finally to Los Angeles. All through this, I booked hotels in Ontario and Walnut and couldn't cancel either because Major informed me that the exam could be held at either location. I emailed the bar several times only to be told that I had to contact Major. I lost money on the hotels. In between all this, I received red line versions of the Kaplan questions, which further interrupted my studies because the MBE material that was given was wrong. After expressing frustration and anxiety in an email to the bar, I finally received a response that I would be at the Los Angeles location. I still couldn't cancel my hotel, and I received an email just days before the exam that I would be taking the exam in Los Angeles. Taking the exam itself was also frustrating because since there was people talking in the hallways, we couldn't concentrate as we should. At least in our room, we were only given one 30-minute warning, and for the rest of the 4 essays, we were only given, or 5 essays, or 4 essays and 1 PT, we were given only a 5-minute warning and a 1-minute warning. Further, it has come to light at the last trustees meeting by several renowned professors that there's a 27% error rate on the release 25 MBE questions. Thank you. I appreciate your time, but I just want to assure you this sounds like a story, but it is not. I had a lot of stress and anxiety. So I just wanted to express that to you. Thank you.
Thank you, Ms. Big.
Our next public comment is from Mary Basic.
Hi, thank you. My name is Mary Basic, and I'm the Assistant Dean of Academic Skills at UC Irvine, and I am continuing with point 2 of the joint statement of the bar prep professors, which was introduced by Katie Moran and Ann Camacho. We have concerns about the materials that have been released by Kaplan and the questions and the validity of those questions. I am also one of the professors who was originally invited to do the standard setting and was then disinvited based on some conflict of interest that I do not at all understand. So in addition to the content map, adding 34 subject areas, why that is so problematic is because, one, it was unilaterally done. It was done at the last minute because that revised content map was distributed to students maybe 2 weeks before the exam. If you've studied for the bar exam, you understand that having material brand new that there is no practice questions available for is going to not only not prepare you for the exam, but when you get to the exam, that's going to throw you off when you're being tested on topics that you were not prepared for. Since Kaplan has only released a total of 50 questions, the students had to use published materials in order to prepare for the exam, and none of this content would be included in those materials. In addition, as mentioned, I reviewed the faculty guide questions. There were definite problems with them, and this is after they had been revised. There were still 24% of those questions were completely problematic and should not have been utilized. I am, as my colleagues, are very concerned about the quality of these Kaplan questions and the content being tested. Thank you very much.
Thank you, Professor Basic.
Our next public comment is from Anna Park von Simon.
Hi, can you hear me?
Yes. Good morning.
I just wanted to echo what Mary Basic said and really hone in on the fact that the Kaplan questions had so many issues. Both the release questions, where there was a massive error rate even before they were corrected, and then even after being, quote, corrected, they still had a lot of errors. The actual questions that we took on the test the day of had typos, they had grammatical errors, some of which changed or made ambiguous the meaning of the question itself or the answer choices. They had incorrect law, they misstated rules. It was just absolutely impossible to do as well as we otherwise should have with these absolutely problematic questions. Additionally, there was no transparency in how these questions were created. Every other state licensing board uses subject matter experts and has quite a bit more transparency in the process. So I just think it would be extremely unfair to be able to grade these exams and decide whether someone is minimally competent when these questions are not minimally competent. Thank you.
Thank you, Anna.
Our next public comment is from Robert Dukas.
Last summer, good morning. Last summer, I was one of the thousands of persons who received an unsolicited email from the State Bar inviting us to participate in phase 1 of the California Bar Exam experiment held this past November. I did sit for that exam. The enticement of the participation was the possibility of qualifying for up to 40-point score adjustment on the multiple choice portion of one's first attempt of a 2025 general bar exam. The California Supreme Court approved the phase 1 scoring adjustments. The results of the experimental exam will affect the scoring of many applicants taking a 2025 general bar examination based on what's been published. 4 months have elapsed with no indication of when the results of the experimental exam will be released. While the following 3 questions won't be answered during this meeting, they must be addressed. When will the results of the experimental exam be released to the participants and the public? 2, what is the minimum threshold performance score to be eligible to receive additional points? And 3, how many points will be awarded for the multiple choice section of the 2025 general bar exam if a person is not successful on the bar exam after the first read? It's my understanding that's how that would apply if you got points at all. Because there have been numerous comments opining that the experimental questions were crafted poorly when compared to the NCBE questions, justice would be served to award the full 40 points to the participants of the exam. Don't penalize good faith exam takers who did not create the questions. We relied on the possibility of receiving up to 40 additional points for our participation, which was solicited by the State Bar. Thank you for your time and consideration. Have a great day.
Thank you, Mr. Dugas.
Our next public comment is from Douglas, who I believe is in the SF office. If the conference room could be unmuted.
Hi, can you hear me?
We can,
Yes.
thank you.
Thank you. Good morning. I was an applicant at South San Francisco, and two things I haven't heard discussed are the stress from the experience and time for the remedies. First, the stress during the exam caused by the technical issues. We are discussing quantifiable issues such as essays we could not submit, CPTs we could not access, or lost time at various points throughout the exam. One thing that is not being addressed is the stress we experience due to technical issues. What is the psychometric analysis for someone who had an applicant next to them screaming for a proctor and yelling something to a friend 3 rows behind them after their connection dropped? How do you psychometrically analyze someone who is frantically worried that the connection will drop again during the multiple choice section? You can't. The approaches to our experience have not taken that component of the exam into account. It is impossible to quantify the detrimental impact of the losses in connection and distractions. You cannot apply psychometric analysis to stress and distractions during the exam. Second, time in the remedies. The discussion of potential remedies seems to focus on refunds and retakes, but the most demanding component of the exam is the time that goes into preparation. I studied every single day for 3 months, including holidays. I woke up at 4 a.m. to study before going to work. I then studied on lunch breaks and weekends, essentially working a 7-day week for months. But I feel like I'm one of the lucky ones. I am not a parent who missed time away from their kids. I have an understanding employer who gave me time off. But some people lost time with their kids and used up finite vacation days for this exam. To have to go through all of that work again because of technical issues that are the fault of the California State Bar is a gross injustice and substantially unfair. Refunds and retakes do not give us time back we spent studying. Many of us put forth a past-worthy effort of studying that may be wasted because of the way this exam was administered. I believe the remedy must be a dramatic score adjustment and a provisional license, and then a pathway to full licensure without a retake for those who did not pass. A remedy involving a retake is not a remedy to those who dedicated 3 months of their lives to preparing for this exam. We can't get those 3 months back. Again, you cannot psychometrically analyze the stress and distractions caused by the technical failures, and a refund and a retake do not give us our time back. Thank you.
Thank you.
Our next public comment is from Todd Hill. Todd Hill, you've been unmuted.
Before this committee discusses psychometric analysis and past practices, let's be clear. The February 2025 bar exam was a failure, but not just a technical failure. It was a failure of oversight and accountability. No amount of jargon can obscure the fact that thousands of applicants were harmed. The focus today should be on full transparency and meaningful accountability. Yet here the focus appears to be on data points and damage control. My name is Todd Hill, and I speak today not only as a law student and bar applicant, but as someone deeply invested in the integrity of this profession. I've spent years examining the State Bar's regulatory failures, studying their patterns, their decisions, and the impact those failures have had on law students, bar applicants, and the public. The February 2025 exam was the inevitable result of years of neglect, a pattern of abrogation that has long compromised the public's trust. This event serves as clear demonstrative of its breach. Thousands of applicants who invested years of effort and thousands of dollars faced a system that failed at the most critical moment. And yet, instead of swift accountability, the State Bar's response is a privileged and independent investigation, terms that, in this context, raise more concerns than confidence. Privilege means the truth can be concealed. Independent means whatever the bar decides it means. This is not transparency, it's containment. The exam failure was public, the harm was public, and the remedy must be public too. The data this committee will review today focuses heavily on completion rates, yet those numbers tell an incomplete story. The reported completion rates fail to capture a critical reality. Many test takers fought through hours of technical issues, enduring screen freezes, lost answers, and unstable platforms, yet they managed to finish. Their completion doesn't erase the extra stress, the lost time, or the heightened risk of being flagged by a proctor, a risk that jeopardized their exam results through no fault of their own. I urge you to delay, reject secrecy, and demand full transparency. Anything less risks confirming what too many already suspect, that the bar protects itself first and is due to the public second, if at all. Thank you for your time.
Thank you, Mr. Hill.
Our next public comment is from Victoria N.
Thank you. I'm here to speak on behalf of a specific group, the 352 attorney applicants from last month. We suffered distinct harms and we have fewer available remedies now. Specifically, a few remedies won't meet our needs. We didn't take the MCQs, so a botched essay experience can't be given any less weight in scoring. Our group includes practicing solo attorneys and general counsels who won't benefit from a supervised provisional licensure. And since practicing attorneys can't take multiple months off work, a free makeup exam in July holds less value for us than for new grads. There are 3 potential remedies that are appropriate. The first is reciprocal admission. While a Supreme Court opinion last year reaffirmed using an attorney's exam, California already bypasses the need for that exam for specific groups like military spouses and legal aid attorneys. The MJP program authorizes them to practice fully because their hardships outweigh the risks posed by bypassing the exam. Here, we have years of demonstrated competence, with some of us already practicing in California through the MJP program, and our full workloads mean that we'll face unique harms from a July makeup. Thus, offering us reciprocity extends us the same grace that's given to military spouses. Second possible remedy is scoring adjustment. Post hoc, it's impossible for CBE to know which takers had technical difficulties on which essays. The committee should ask the court to authorize a flat score increase or to use an adjusted algorithm based on an examinee's highest essay score. It's a remedy that works for all takers. And the third remedy is a PT and PR only makeup exam. The committee should recommend that attorney applicants who are forced to retake in July redo only the PT and professional responsibility portions instead of rememorizing 10 or more subjects that are irrelevant to our current practice. That's in line with the Supreme Court's prior recommendation to consider allowing unsuccessful applicants to retake only the components that they failed. Ultimately, we simply ask that you ensure that we don't get less of a remedy than others do. Thank you.
Thank you, Victoria.
I'd like to note for the record that Kareem Gangora has joined from the LA office. Our next public comment is from Reza.
Hi, everyone. I appreciate you taking the time to hear our concerns. I'm a test taker with accommodations, and during the February exam, my accommodations were effectively stripped due to the performance test crashing, cutting into my time. The first 20 minutes, I had no access to the file and library because the link was broken. Then the PT crashed with 20 minutes left. The entire exam was a disaster, delayed by over 2 hours, multiple choice questions riddled with grammatical and spelling errors, and no option to strike out wrong answers. On top of that, I had a constant red pop-up on the right side of my screen saying could not save, just constantly reappearing on the entire right side of my screen. Extremely distracting. I could literally feel my blood pressure rising as I was trying to ignore this. This exam already imposes a massive financial and emotional burden. We made significant sacrifices, taking time off work, being away from our families, and investing months into prep, only to be met with a flawed testing experience. We demand a big score adjustment, allowing us, or provisional licensing, allowing us to work under a supervising attorney toward full licensure. Thank you again for your time.
Thank you.
Our next public comment is from Nadine. Nadine, you've been unmuted.
Good morning. So we were told that preliminary data suggests that those of us who submitted the exam were able to complete approximately 98% of it. What does that mean? It means that we were able to write an answer and submit it. That's it. It doesn't take into account the conditions under which we wrote that answer and the impact those conditions had on our ability to perform. What it took to get through the February 2025 California bar exam bears some repeating. Midway through the multiple choice section, I found myself pleading with a proctor to log me back onto the exam. only to be told that the website had crashed and there was nothing more he could do. I asked him to keep trying. Eventually, I got back on. At another point during the essays, the page kept refreshing every time I hit the space bar. So I was essentially typing to a blinking screen. I then received multiple messages telling me that my answers weren't even saving. My exam ended 3 hours later than it should have due to disconnections and delays in checking in. To get through this exam, you had to endure an unreasonably high level of anxiety. It was virtually impossible to maintain your focus and morale in the face of so much confusion and disruption. Yet so many of us hung in there. We limped our way to the finish line under these extraordinary testing conditions, and I believe that in doing so, we did in fact demonstrate minimum competency. I respectfully ask that we all be able to pass. Thank you.
Thank you.
Our next public comment is from Ernest, who I do not see in attendance. Our next public comment is from April Vincent.
Hi there, I'm April Vincent, and I'm continuing with the joint statement of bar prep professionals, Katie Moran, Ann Camacho, and Mary Basic. I'm an associate dean at the Colleges of Law. And our next point is about the electronic modality for multiple choice questions and how that's a bad idea. So examinees we know will be testing in person for the July bar exam. And the fact that examinees have enjoyed this type of task testing, including testing electronically at other times, is moot. The bar has not revealed the question asked on these surveys, and the bar has not revealed how many examinees responded. So therefore, we respectfully encourage the CBE to ask law schools to poll their graduates to see if they want to know whether applicants really want to be tested electronically or tested in person. We have not heard of a single examinee who has said they prefer electronic administration of multiple choice questions. We also urge the bar to move back to a paper format for all essays, the PT, and the multiple choice questions, where examinees can mark up and eliminate questions freely. The bar will not have to redesign and test software or worry about the horrible glitches that we've just heard about. Everyone will be able to test at the same time as opposed to the rolling starts that cause so many problems. And paper modality is easiest for most examinees to use. We urge the bar to use paper format for all materials except those requiring electronic accommodation. Thank you very much.
Thank you, Ms. Vincent.
Our next public comment is from Nadia Johnson.
Hi, thank you for having me. My name is Nydia Johnson, and I am the Associate Dean for Academic Success and Bar Prep at Southwestern Law School. And I am continuing with point 4 of the joint statement of bar prep professors, which have included Katie Moran, Ann Camacho, Mary Basic, and April Vincent. And I will be suggesting to the bar here scoring adjustments for the multiple choice questions. The State Bar should publicly release and then conduct a rigorous review of the Kaplan drafted multiple choice questions. Historically, Kaplan drafted questions have tended to test on minute and uncommon rule details, recite incorrect law, and have not always followed best practices regarding length and drafting protocols. We all strongly recommend that the 200 February multiple choice questions be carefully reviewed by subject matter experts on the Black letter law and multiple choice best practices by the academics working in bar prep and academic support. As the bar is aware, many of us have been precluded from participating in any type of validity panels to review these questions. After a proper review, only questions determined to be sound should be graded, and the passing score should be further adjusted to account for the disruption caused by the ambiguous and poorly drafted questions, as well as the platform difficulties. The passing score should be further adjusted to account for those, as well as the issues of the answer elimination tool, the non-functional highlighting, and the annotation tools, and the lost time for connectivity problems and proctor interruption. There are many more bar prep academics ready and willing to volunteer to do this, and we hope the State Bar will allow us to participate in this process. Thank you.
Thank you, Dean Johnson.
next public comment is from someone with the phone number ending in 8252. I do not see them in attendance. Our next public comment is from Katie Yemen.
Hello, my name is Katie Yamani, and I was a test taker, a February 2025 test taker. My family relocated to California. I am in an interracial relationship with a woman, and we have 2 sons who are Black, and my wife is also Black. We can't live in all parts of this country safely. We chose California because of the incredible protections that are here for LGBTQ people and for people in the Black community. I am barred in a different state, and it has been incredibly horrible. It's been an incredibly horrible process. I'm worried because the deeper I've looked into the California bar, I've realized how untouchable this bar seems to think it is. It is not generous to give us the ability to try to pass the July exam, and any anger or frustration shown to the February test takers by the trustees or anyone on the board is wrongfully placed. I believe that you knew that this was going to happen, that this disaster of a test experience was foreseeable, and you decided to go forward without any idea of how to remedy these problems after they happened. We were used in a way that deserves respect and attention, and I ask that you give us a fair remedy for this experience.
Thank you, Ms. Yamani.
Our next public comment is from Bryce Woolley.
Thank you, Devin, and thank you, Board of Trustees. My name is Bryce Woolley. I am an associate professor for academic success and bar preparation at Southwestern Law School. I am continuing with point 5 of the joint statement of bar prep professors introduced by Katie Moran and continued by Ann Camacho, Mary Basic, April Vincent, and Nydia Johnson. Point 5 is a suggested scoring adjustments for essays. The essay grading of the February 2025 bar exam must be modified to account for the numerous and significant system failures experienced by all applicants, not just a few applicants offered an exam retake. This can be accomplished in 2 ways. 1, by creating rubrics adjusted to account for the exam disruptions, and 2, by grading all written work, but then only counting each applicant's top 4 scoring documents to determine their written work score. The State Bar should consult with subject matter experts, such as academics working in bar preparation and academic support, to assist with creating rubrics that identify an applicant able to demonstrate competency to provide law despite the platform inadequacies. Every applicant should be allowed to retake the performance test if they wish. Lastly, we urge the CBE to request that the California Supreme Court extend provisional licensing to applicants who did not have the opportunity to complete enough of the exam to have it graded, or who are unable to demonstrate competency to practice law, be given an opportunity to retake the bar exam at no cost, 1 free retake, at a later time that works best for them, and attorney applicants should be granted reciprocity. Thank you for your time.
Mr. Woodley.
Our next public comment is from Ashley R.
Hi, good morning. I would like to propose that the State Bar should refund all February applicants because the exam was unfairly administered. They falsely assured us that the technical issues were resolved, yet we all experienced otherwise. This misrepresentation compromised the integrity of the exam and unfairly impacted our results. we now have to purchase expensive bar prep programs again. And this refund wouldn't undo the damage, but it could at least cover the cost of preparing for a fair exam. And also, I know a lot of people are advocating for a provisional license, but that would force me to leave my job just to fulfill the required hours. And that creates a lot of uncertainty for me and other colleagues that have a state job. And if a provisional license are issued, I would like to have at least a consideration that state agencies should allow people with provisional license to practice law, so people like me aren't forced to choose between our careers and a stable income versus comparing the ability to practice law. So if it's granted, we should not be required to take the bar exam. And for many of us, like, this is our one shot and we should not be forced to take another unfair exam. That is all. Thank you.
Thank you, Ashley.
Our next public comment is from someone with a phone number ending in 91908, who I do not see in attendance. Our next public comment is from Anna Bolito. Anna, you've been unmuted.
You're still muted. You can unmute the button.
We can go back to Anna.
Agreed.
Our next public comment is from someone with just the name Jennifer and the phone number ending in 0723, who I do not see in attendance. Next public comment is from someone with the name McAllister, who I also do not see in attendance. Next public comment is from Mia.
Hello, good morning. My name is Mia Mogavro, and my comment is regarding potential remedies related to the administration of the 2025 bar exam. I personally benefited immensely from the provisionally licensed lawyer program offered to 2019 to 2020 graduates. This program bridges the gap between law school and full licensure. The Blue Ribbon Commission already invested countless hours in time, money, and resources into the beautiful report submitted to the Supreme Court, offering this alternative pathway to portfolio bar exam. This is my firm belief that today an exam cannot and does not showcase one's ability or competency to practice law. I have circulated an online petition in support of reconsideration of the portfolio bar exam and have amassed over 105 signatures from students willing to support this petition. The committee must recognize and put forth an option to the Supreme Court, and I am more than happy to work with the State Bar to provide any insight regarding the practicality of the provisionally licensed lawyer program or one's ability to comply with the written requirements of the portfolio bar exam. It is extremely important that other students are provided an option to bridge the gap and not lose out on opportunities granted to them because of the hard work they've already put into getting by being able to actually graduate from law school. And I also support Marcus Friedman's comments regarding the portfolio bar exam as well. Thank you so much.
Thank you, Ms. Mangavero.
Our next public comment is from someone with the name Ami, who I do not see in attendance. Next public comment is from Susan Freyer.
Hello, my name is Suzanne Fryer, and I am an assistant professor of law at Pepperdine Caruso School of Law. And I'm continuing with part 6 of the joint statement of bar prep professors introduced by Katie Moran, and then followed up with by Ann Camacho, Mary Basic, April Vincent, Nydia Johnson, and Bryce Woolley. First of all, just continuing with the adjustments for the written portion of the exam, I just want to emphasize the fact that every applicant should be allowed to retake that performance test if they wish. It would be unfair to attempt to assess a score psychometrically based on essay score, since the PT is a very unique testing modality that emphasizes different skills than the essays. The retake could be offered in the evening or whatever you need to do to minimize disruption. And if it's impossible to fix the platform failures before administration, then every applicant should be afforded at least 30 additional minutes to make up that platform inadequacy. And then just in summary, I just want to say that in general, we need to pass those who can be passed, but no one should fail this February 2025 bar examination. The grading goal should be identify the applicants that, despite the significant challenges, were still able to demonstrate the competency to practice law on the February 2025 bar exam. The bar cannot repeat any of these mistakes in July. There are too many examinees at risk using these substantially different, lower quality, unvalidated multiple choice questions. We urge the CBE to please return to the MBE for some time and to regroup before taking next steps much more carefully. Thank you for your time. Each of us and many others of our colleagues is ready to volunteer, as we'd like to have before, to help the bar to remedy this situation for February examinees and to prevent future harm in July. I appreciate your time.
Thank you, Dean Fryer.
Our next public comment is from Maria Dominguez, who I do not see in attendance. Going back to Ann Carbolito. And you've been unmuted if you wish to provide a public comment. Okay, with that, that concludes the advanced signups. Is there anyone at any of the notice locations that wishes to provide public comment? See none. Our next public comment will be from Andrea.
Hi, the first thing I want to say is I want to say thank you for Alex Chan for your empathy and candor and how you're communicating with us applicants. I think that's the first comment that we have received where it shows onus on the state bar instead of placing the blame on us, because we are here today and I'm sure you all know why we're here, and it's because of the state bar's error and fault. And so Alex, thank you for your candor and actually treating us like humans, and it's not our fault. Today, I'm not going to belabor the issues with the exam. I didn't get to complete my exam and I do not get to qualify for the retake because of the unclear parameters that were established by the state bar for those that can take the retake. I just want to say for parametric scoring, I don't think it's fair to compare or do provisional licensure similarly to how you did the February or the 2020 bar examinations, because it's a completely different exam. I would describe it's a new platform. Measure Learning doesn't have the same functionality or capability as that of Exemplify that was used previously for the 2020 exams, and we are provided with a new question type. We were only given a sample of 25 questions to prepare to take a 200 question MBE test. Imagine sitting at a test and you have 200 questions. It's basically like learning a new language. The writing style is different, trying to figure out responses. In addition to, Mary Basic and other deans that have identified, some of the answers were wrong and we were tested on incorrect portions of law. So utilizing that as a base to grade prometrically this exam is just not fair. It's not equitable. And I don't think the bar is fully appreciating, yes, 98% were submitted, but all of the factors that went into submitting the exam. People yelling and screaming during the tests, proctors controlling our mice without our consent, erroneously submitting the exam before we had an opportunity to complete, like I did. I didn't get to complete the last MBE session. So please have empathy and compassion for us all.
Thank you for your comments, Andrea.
Our next public comment is from Laura Price.
Good morning. The February 2025 bar exam was an unprecedented failure, yet the proposed solutions rely on past exam metrics that fail to reflect what test takers endured, like myself. The bar's appointed psychometrician's role, Chad Buckendahl, should be to address this unique situation, not apply outdated models from exams that didn't experience these discussions. Today's agenda item 4.1 acknowledged the issues unique to this modality, remote or in person, is an additional complexity, means that a single solution may not be appropriate for all test takers. The type and severity of the disruption needs to be explored to better understand how the disruption potentially impacted scores for an applicant. Since this is true, why rely on prior exam adjustments like those used in July 2021? Additionally, I request the following in response to the options for reducing the grading timeline agenda item. The grading timeline should not be reduced. The second read must not be eliminated. Clarification on the elimination of calibration meetings. What does this entail and why are these meetings fundamental to fair grading? And transparency on AI use in grading. The agenda acknowledges AI grading is in its quote early stages. While AI may have a role in grading, now is not the time to introduce an untested variable when fairness is already in question. AI should not be used on this exam unless a detailed public summary explains its role, safeguards, and limitations. Every applicant deserves a clear, individualized explanation on how their score was determined with the full psychometric analysis made public. There must also be a transparent and accessible appeal process. The State Bar must prioritize integrity over administrative convenience. The State Bar cannot afford to ignore the gravity of this administration's failures. Test takers like myself deserve accountability and fairness. Unprecedented failures require unprecedented solutions. Thank you.
Thank you. Our next public comment will be
Devin,
from.
actually be mindful that we have less than an hour left for the public comment section, and I really want to have as many comments as possible. And so I'd like to at least call for those who would like to speak for 1 minute to go first. That way we can maximize the number of voices heard. So with that, Devin, can you please call for those who are willing to speak for 1 minute first? And then once we're done.
Jean has her hand raised.
Oh, okay. Jean, please.
That was entirely unintentional, so I apologize for that. Sorry, Audrey. Sorry.
Yeah. No worries. Yeah, so with that, Devin, can we please call for those who are willing to speak for 1 minute first? And once we're done, then we can come back to those who would like to speak for more than 1 minute.
I see Ashley with her hand raised.
Hey, Alex, before we do that, I was just wondering, will that mean that everyone will be out of order again? I would hate for the people, I know at the Board of Trustees, we didn't get to hear everybody. And so I would hate for everyone to lose their place if we have to put everyone's hands down to get everyone's hands back up for a minute. Do you know if there's a way to solve for that?
I don't. Devin, do you have any recommendation?
The only thing I can say, Alex, and sorry, Devin, I'm going to step on you, is we currently have 39 hands raised, I believe, but some may be duplicative of others who've already spoken. So if we maintain the 2 minutes at this point, almost everybody in that pool who currently has their hand raised may be able to make a public comment. So I just offer that for your consideration.
Yeah, we have less than an hour left with 39 commenters, and assuming 2 minutes each, we're going to go over that hour easily. Jean.
We began public comment at 9:09, so we have almost exactly 1 hour left, Alex. So I'm just offering that as any assistance it may be, but it is within your discretion.
Okay. Let's. I do want to have as many voices heard as possible and giving people as many minutes as we can. So let's just stay on course and let's just continue on and let's see where we end up. Let's say in about 45 minutes from now.
I do see someone who did sign up in advance now in attendance. So Maria Dominguez.
Thank you, Devin. Good morning, everyone. My name is Maria Dominguez, and I'm a member of the California State Bar. And I'm also the president of the California La Raza Lawyers Association. We are the Latino Bar Association of California, representing 16 bar associations throughout our state, including Northern California, Central California, and Southern California. We joined the numerous calls for accountability. We're deeply concerned about the lasting consequences this crisis will have on directly impacted bar applicants, as well as the members of the public. We are also concerned about the disproportionate impact this will have on the Latino community, as we are already severely underrepresented in this profession. This will inevitably further delay and deny the opportunity to grow our representation, and especially at this time in our history, when our communities are being called to be at the front lines of providing legal services. This crisis is an opportunity to reform the California bar exam, and this has to involve all of us, this board, our California Supreme Court, our legislature, our members of our state bar, and the members of the public. To the applicants who have been struggling to pass the bar exam for years, to those who have endured through the failures, I see you. I was once there. We must make this right with urgency. Justice delayed is justice denied. The California La Raza Lawyers Association is here to be a partner. We urge you to take action. We will be here with you, and we can do this. Thank you.
Thank you for your comments, Ms. Dominguez.
Our next public comment will be from Ami, who also signed up in advance and I now see in attendance.
Thank you and good morning. I respectfully propose that the board formally request that they enact a program to allow practicing attorneys to gain admission to the California Bar for the July 2025 session upon motion. Folks have been calling this bar reciprocity. As bar reciprocity program would reduce the complexity of the California bar exam by removing the separate attorney examination format and would reduce the number of bar exam participants during this turbulent year. The upcoming July 2025 exam will have an unprecedented number of takers. For this time period, attorneys who are in good standing and are able to join the California Bar upon motion would be implemented in consistent practice with many other states. This change would also maintain the quality of legal representation in California and expand access to justice in this state. Thank you for your time.
Thank you, Amy.
Our next public comment will be from Sonia C.
My name is Sonia Chen. I am a first-time February 2025 bar examinee, and I qualified for the retake. Yesterday, I completed my mock exam, and I experienced significant technical issues, including the inability to launch the performance test. My proctor did not speak proficient English to support my issues, and worse, she did not know what exam I was taking. I have continued to study full-time, incurring significant financial hardship, relying in good faith that I would have a fair and reasonable chance at a retake. However, after yesterday, I believe I am being set up to fail. Measure Learning has no incentive to provide a competent platform for retakers. While technical solutions may not be feasible this deep into the disaster, providing well-trained proctors who can communicate clearly is feasible for such a small group of retakers. I'd like to use my remaining time to state that the retake itself is unfair to my brilliant peers who were arbitrarily robbed of this opportunity. I honestly feel that I need to betray my sense of integrity and fairness in order to enter this profession in California. Also, this administration has discriminated against disabled examinees, which is unconscionable and the antithesis of the inclusive mission that the California Bar mission seeks to uphold. And I'd like to remind everyone on this call that all of you were born into this world by a disabled person. So dismissing the complaints of disabled applicants is absolutely disgusting. Thank you.
Thank you, Ms. Chen.
Our next public comment is from someone with the phone number ending in 7192.
Good morning. My name is, can you hear me?
Yes.
We can.
Good morning. My name is Jamilette Castro Gallo. On March 5th, 2025, I submitted a testing accommodations petition for the July 2025 California Bar exam. I submitted my initial testing accommodations petition in connection with the February 2023 exam. I feel profound futility due to the discriminatory accommodation procedures of the State Bar of California and the Committee of Bar Examiners. where those of us who are diagnosed with disabilities as adults are denied the opportunity to obtain the same result, gain the same benefit, and achieve the same level of success as non-disabled applicants. Consultants that are hired by the Testing Accommodations Office have ignored established legal standards when recommending denials. For this last petition, you now have what I have had to spend thousands of dollars of quote-unquote objective evaluation that you have been insisting on receiving, and I hope that you will take the time to make a fair decision this time. I did not take the February 2025 bar exam, not by choice, but because of the lack of competence of the Testing Accommodations Office, which did not let me know about my testing accommodations denial until 2 days before the actual phase 1 experiment exam. Thank you for your time.
Thank you.
Our next public comment is from Becky Hoffman.
Good morning. Thank you for your time. I wanted to echo previous commenter Katie Yamani's sentiments as a fellow queer woman and February bar taker. This institution's mission statement states that it supports efforts for greater access to and inclusion in the legal system. Yet the administration of last month's exam prevents exactly that. So many of us who took the exam are non-traditional students. We attended California accredited law schools. We have full-time jobs. We have families. We do not have the luxury of taking additional time off, nor do we have the financial means to do so. All we want is to gain licensure so we can contribute to the legal profession in a meaningful way. I see Justice Mesiwala on Zoom, and that gives me hope. You've been an advocate here in Santa Barbara in your participation in the Unity Bar and the Diversity and Equity and Inclusion Task Force. Lets me know that your participation on this board can only help, and I hope that the rest of you take seriously the problems that we've encountered. Lastly, I want to thank board member Alex Chan for his opening comments this morning. I agree that these meetings must be conducted with civility, decorum, and respect, but this goes for board members as well, and I ask that the bar hold Board of Trustee Mary Huser to the same standard. Her behavior last week was nothing short of disrespectful and dismissive. Rolling her eyes, eating, talking, chewing gum, and then spitting out her gum and waving it at the screen while smiling derisively was a virtual slap in the face to all of us who shared our very real and very palpable pain. I ask that action be taken on behalf of my fellow bar examinees. Thank you.
For your comments, Ms. Hoffman.
I'd like to note for the record that Bethany Peak has joined the meeting.
Thank you.
Our next public comment will be from A's iPhone 777.
Hi. Can you hear me?
Yes, good morning.
Okay. It's been 16 days since I've been trying to get a hold of anyone from the state bar about my specific situation. I'm an accommodated test taker, and Guardian Browser completely kicked me out of my performance tests. The technicians finally fixed the issues around 1 a.m., 1 in the morning, past midnight. My proctor represented to me that I can resume the PT at another time because I had another exam in the morning and it was 1 a.m. I double checked on this when I messaged the proctor. I've said, is it a guarantee? I'm scared to leave the exam and not be able to finish it later. I had this written in the text box, and he assured me, and so I relied on this promise. However, as of today, I've not been offered a retake or even a response by the state bar, and a psychometric analysis cannot accurately score my PT based solely on essays 1 through 5, as my scores on the PT have been significantly higher than the essays. My performance shouldn't be artificially suppressed due to the false promises by your proctors. I'm requesting that I please receive the opportunity to finish the PT as promised, or in the alternative, be able to retake the PT in a few days with the other people, rather than receive a made-up score. The PT is around 14% of the overall score and should not be a guess. Please, I got a 1369 and then I got a 1377 on the last bar. I got so far and I tried so hard. So please do not let this be the reason that I fail or anyone else in this situation fail. Please, I'm begging you, please. And thank you, Alex Chan. You're very kind, and It's really heartwarming to hear that you actually care about us. And Trustee Tony, shout out to you. Reddit loves you. Thank you.
Thank you. Hang in there. Thank you for your comments.
Our next public comment will be from Zach Farrell.
Good morning, members of the committee. My name is Zach DeFazio Farrell, and I'm a February 2025 bar applicant. The February exam was a failure of administration, not a failure of applicants. I experienced severe technical failures. Software failed to log my keystrokes. I was disconnected for over 3.5 hours, and I was unable to finish the 5th essay or even begin the performance test. The timer was inaccurate, and proctors took control of my computer and downloaded programs without my permission. These failures were not my fault, and no statistical adjustment can fairly compensate for the loss of my exam. Comparisons to July 2021 are flawed. The February 2025 issues were more pervasive, severe, and variable. There's no historical control group, meaning any psychometric grading adjustments are arbitrary and unreliable. Forcing a retake under different conditions, where some applicants now use Scantrons and Microsoft Word instead of the same software, undermines the very definition of a standardized test. How can the state bar determine minimum competence for future attorneys when it has so clearly failed to meet its own standard of competence in administering this exam? The only fair solution is full licensure for attorney applicants, provisional licensure without a retake for all others, and full refunds for all applicants. Other states, Wisconsin, Oregon, Washington, Arizona, and New Hampshire, already offer alternative pathways. California should do the same by reconsidering and approving the portfolio bar exam as a permanent alternative. I urge you to act now. Thank you.
Thank you, Mr. Farrell.
Our next public comment is from Chris Haynes.
Good morning. I intended to discuss remedies, but you mentioned at the top that you expected to hear from those with good experiences. I believe I had the best possible experience with this test. The performance test had significant issues that were easily foreseen and made it near impossible for every tester to write a competent answer in the time allotted. Then the state bar sent an email on the first night saying I may have to retake some or all of what I just wrote the following week, further exacerbating the massive stress of this exam. We learned this week that in addition to the 25 questions that were eliminated from grading, the psychometrician's report shows that another 40 questions that were graded did not meet the bar's own standards for difficulty, totaling 65 of the 200 questions that do not meet the bar's internal standards. The poor quality of these questions was apparent during the exam. We have all seen hundreds or thousands of practice questions, and after beginning to see issues with poorly written or seemingly incorrect questions on test day, you begin to second guess the test itself. Asking yourself if the test knows what it is testing for 200 questions massively slows down the exam. And then, like seemingly everybody else, during one section, I disconnected a dozen times and the test paused for half an hour. So if you want to hear about a good experience with the exam, unfortunately, this is it. These issues were not outliers, they were inescapable. I appreciate the state bar's time and focus to help make this right.
Thank you, Chris.
Our next public comment is from Lynn.
Ms. Lynn, you muted.
Okay, can you hear me?
We can hear you now.
Okay, thank you. Dear members of the community, good morning. We totally agreed with the first comment from Benjamin. Thank you, Benjamin. We respectfully urge the committee to continue offering the remote as option or accommodation for the July 2025 administration and beyond. As noted in the March 5 to the Board of Trustees, the issues experienced during the February 2025 exam were due to vendor-related incompetence, which affected both remote and in-person test takers. The core issue lies in resolving vendor capacity and performances, not in eliminating remote, as in-person also faces even more serious problems as well. So simply canceling the remote option would introduce greater unfairness. Many candidates made important life arrangements based on the announcement in October 2024, under the detrimental reliance of future remote tests, including but not limited to registering and paying hundreds, even thousands of dollars, opting out of February in preparation for July, and withdrawing from the February exam based on CalBAR's advice. and the understanding that July 2025 would offer a remote option. We understand that the Supreme Court has made a statement regarding in-person only, but if remote testing is not offered or provided as accommodation in July, we respectfully urge the committee to consider how to fairly compensate affected candidates. We would like to offer 3 proposals. The first one would be continue to offer remote tests for future test takers. And the second would be full refunds for candidates who registered since the October 2024 announcement, including registration fees, moral character determination fees, and any related fees, and provide coverage of travel costs for candidates who withdraw from the February 2025 exam. Thank you.
Thank you, Ms. Lin.
Our next public comment is from Michaela Robinson.
Good morning. I am a February 2025 retaker, initially taking July 24. I am also a candidate with disability accommodations. I've experienced, the issues that have all been stated, so I'm not going to belabor the point. However, my concern is more so with the lack of any kind of comment or addressing from the bar regarding the accommodated test takers, primarily that we were basically promised that measure would provide locations closer to home. That was kind of the point. And myself and many others were still placed over 2 hours away from our homes due to the inability to find test taking. I'd also emphasize the fact that delays in the software on test days really can impact those with disabilities. For me, being diabetic, I only brought enough snacks, assuming it'd be 3 hours flat. And then my morning sessions ended up being closer to 4.5. So it did affect blood sugar and things like that. So that does impact the ability to perform. I would like to specifically shout out Audrey Ching. She, before the test date, really took it upon herself to try to help me find a local testing location by my house. Unfortunately was not able to, but I just felt that her time and attention really should be recognized. And I do appreciate you all hearing what we have to say today and in previous meetings. Thank you very much.
Thank you, Ms. Robinson. And Audrey, you are so recognized. Thank you.
Our next public comment will be from Isai Ambrosio.
Good morning, members of the committee. Like others, I'm here to share my experience with the February bar exam. I'm a Latino applicant in Santa Cruz County. What happened to us was not normal. The mental, financial, and professional impact of this experience may last for years. This was not my first bar exam. In 2024, I made the commitment to take it again, fully aware of the time and money that it would require. My wife supported me, knowing she would take on full responsibility for our son. I invested heavily, $7,700 for a private tutor and bar preparation course, $355 for an MCQ online program, $350 for an essay program and subject outlines, $1,028 for exam fees, $570 for a new computer that I bought specifically to take the bar. I didn't add any other programs, and other office supplies for a total of more than $10,000. I also took 6 weeks off of work to study and take the test. I also skipped a 3-week vacation with my wife and son to focus on studying. These are benefits and money that I will never get back, and quality time with my family. I started to study on November 8, 2024. My focus was on mastering the law and refining my writing skills, but nothing could have prepared me for the technical failures that we faced. On day 1, there was lag when I was typing. The second day, I didn't leave my room just because I was so afraid of the proctors. I didn't take a break, I didn't eat, and this caused me a lot of stress and mental anguish. Given these circumstances, please take action or support our efforts that would alleviate our injuries, including adjusting our scores, or provisional licensure with eventual full licensure after 1 or 2 years. Thank you for your time.
Thank you.
Our next public comment is from Claire.
Morning. I'm a licensed California attorney and I run the LSFN Public Interest Fellowship, where we've had 40 new law school graduates successfully participate. It's a primary example of how supervised practice is, in fact, the best way to test for minimum competency and protect the public. It's time for the state bar and for this committee to stop focusing on grading adjustments and retakes. It is a wasteful exercise, both in terms of time and cost. It is time to focus on the real remedies. I've outlined them in detail in the public comment that I provided to the CBE as well as the Board of Trustees. As Alex Chan himself very artfully noted in his dissent to the BRC report, it is time for California to have options when it comes to licensure. This is a primary and perfect opportunity to utilize options. Specifically, anyone who would like to take the July 2025 exam or the February 26 exam without cost should be allowed to do so. Those February applicants who would like to participate in a portfolio bar exam should have that option as well. This is not asking the court to reconsider its primary order, as this would include a very different population, in fact, a population that is more ideal than using the 2020 PLLs. As for the 2020 PLLs, it is time for them to receive full licensure. Not only will this free up seats for the July bar exam, these individuals have more than proven their competency to practice, and they are serving low-income and moderate-income Californians. Finally, the attorney applicants have proven their capacity to practice law safely. And again, this will also help with the reality that there will be more than 10,000 people trying to take the California bar exam in July. Currently, the state bar has only 7,500 seats. Again, it's time to focus on the remedies. Thank you so much.
Thank you, Claire.
Our next public comment is from Lisa. Lisa, you've been unmuted. Our next public comment is from Jolan Storch.
Hi, good morning. Can you hear me?
We can.
First-time test taker. I'm a foreign educated attorney called in 3 other common law English jurisdictions. On the premise that I would be hired by a California employer after passing this exam, I put my life on hold, significantly impacting my income, my family, and my future job opportunities in order to study for 4 months for the California bar. Lots of people may benefit from provisional licensing, but that is not an acceptable remedy for me. If you plan to scale the rest of us, along with the November experiment people who were first in line, I would also be very disadvantaged by that. Not a reflection of my competence, a reflection of people who were first in line being adjusted to scale the rest of us lower. How will the rest of us be affected by this group who should be compensated in some way for their time being your first guinea pigs for this remote exam? All I expected from you was a fair testing experience. The same time as everyone else, the same questions as everyone else, the same advantages and disadvantages. Lawyers are attracted to this profession to assist our clients in achieving justice and fairness, playing by common rules, established for all to follow the rule of law. We are respectfully asking you to uphold this same standard. We held up our end of the admissions process you established for us. You did not. You did not provide proper oversight, planning, communication, or technology. You did not provide fair questions that were properly vetted or essays that would roll out to the same time in the same order for everyone so no sharing of subject matter could occur. You allowed the same multiple choice questions given to the November takers to appear in this exam. I don't understand how that could reasonably be thought to be fair. The psychometrician wizard may be able to account for some things as an objective adjustment, but this is not what psychometrics are meant to be used for. No amount of regression theory is going to provide that for this particular administration of the test and the stress that it caused and the failure of the tech provider. I have 4 questions for you.
Thank you.
I'd like to note for the record that member Esther Lynn has joined the meeting.
Thank you.
Our next public comment is from David's iPhone.
The integrity of the California bar and the legal profession is at risk. Every institutional failure can be traced back to poor leadership, and the disastrous administration of the February 2025 exam is just the latest example. The failure was not just unfortunate, it was foreseeable and entirely avoidable. Test takers face technical issues, unclear communication, and a lack of proper contingency planning, all of which jeopardize our futures. Meanwhile, every lawyer in California is being forced to pay the ever-increasing annual fees to the bar, making them financially responsible for the institution that continues to fail the next generation of attorneys. Where is this money going? If those in charge cannot ensure a fair, functional licensing program, then every lawyer in this state has a right and a duty to demand answers. Calling the decision to waive the July fees generous only heightens a deep misunderstanding of responsibility. Ensuring access to the legal profession isn't an act of charity, it's a fundamental duty. But fixing this system requires more than just reactive measures. The public must see the bar address the root causes of these failures. And let this be clear, those of us who have been harmed by this incompetence, we're not going away. We're watching. We will not be silenced. We did not waive our First Amendment rights when we decided to enter and pursue a legal career, and we'll continue to speak out and demand accountability and fight for a profession that upholds justice instead of enabling erosion. If the legal system is to retain public trust, it must start with real leadership, leadership that values fairness, integrity, and the rule of law. The future of the legal system depends on it. Thank you.
Thank you, David. Devin, do we know how many more public commenters we have who have their hands raised?
There are a number of hands raised of members of the public who've already spoken, but it looks like around 30.
We have roughly 30 minutes left, and so we probably wouldn't be able to give everyone a chance to speak at this rate. Jean, do you have any objection to us perhaps asking for those volunteers to provide their 1 minute comment first before we get to the 2 minute? Again, I really want to make sure we get to hear from everyone.
That's within your discretion, Alex. What I would suggest, similar to the board meeting, I think what Devin would have to do is put everybody's hands down and ask anybody who's volunteering to public comment in 1 minute to put their hands up, and then those folks will be called in that order. Ashley, I know that doesn't address the issue of folks who have been waiting, but I think that's the best option if we're going to proceed with 1 minute to ensure more public commenters can make comment.
Ms. Guzman, do you have any other recommendations since you have now raised an issue regarding the order? I mean, do you have any other remedies that you can perhaps propose?
No, I think if we're down to the limited, 30 or so comments, that's the only way I can see it working. I just hate for the people that have been waiting for an hour to be at the back of the line. But if they want 2 minutes, that makes sense. So hopefully we can get through everyone.
Okay. Devin, being mindful that we want to hear from as many people as we can, let's just ask for those volunteers who wish to make a 1 minute comment first before we go to the 2 minute group.
Okay, I will lower all attendees' hands. If you would like to provide a 1 minute comment, please raise your hand. With that, our next public comment is from J.R. Jackson.
Hi, everyone. I'll make this brief. My name is Jared Jackson. I'm a licensed attorney in Maryland since 2018. Had to move here in January for family. And now my question of whether or not I can continue the career of being a trial lawyer is in question. I thought about taking the February bar exam, heard about some of the issues, decided no. And given this meeting, I'm kind of understanding why I didn't choose to go. But now my concern is, how do I have some assurance for July? Because I need to start studying that for now. I'm working full time. Have to take care of my 90-year-old in-laws. We've got a teenager. I echo all the sentiments about this is really causing a severe disruption to my life, and I still have to put what I want to do for my career on hold 6 months to a year while the bar figures it out. I think the concern for remedies is kind of important, and how do we give reassurance to folks who, like me, work full-time and need to study now for the July exam, which I don't think you can even open to apply. So that's sort of my comment for today. Thank you.
Thank you for your comments.
Our next public comment is from Pierre H.
Yes, hi, good morning, if you guys can hear me.
Yes.
I was a first-time examinee that wrote the February bar exam in San Francisco. Regardless of my personal circumstances, I have a very different comment than others today. I would like to speak against the proposed resolution in item 4.1, which would allow the vice chair and the chair of this committee to make unilateral determinations on remedial measures if there is no time for this committee to meet before the grading deadline. While I appreciate the chair's comments today, I do just want to note that this committee should instead hold a meeting to discuss remedial measures before any measures are taken. And this is because public comment is vital and crucial to consider before any remedial measures are taken, and specific remedial measures. I will note that this committee's ignoring public comments about how much of a disaster this bar exam would be is the reason why we are here. And so this committee should not repeat that mistake and should not allow the chair and the vice chair to have a unilateral decision-making authority. Thank you.
Thank you, Pierre.
Our next public comment is from KC5.
Hello. I just want to say that it's March 14th and we still can't register for the July exam. We have no confirmation on fees, testing locations, or even if the exam is still happening in July. Thousands of 3Ls are trying to prepare, but we don't know what we're preparing for. Many of us are out of state, need to plan for travel, while others are deciding between California and UB jurisdictions because of this chaos. Bar prep programs like Bar Premium are already beginning. Many of us have spent thousands to get a head start, yet we still don't know what we're studying for because the February exam exposed serious issues with Kaplan's multiple choice questions, not just spelling errors, but fundamental substantive flaws. Many test takers reported, obviously, that the answer choices were completely insufficient for the legal questions being tested. As Mary Basic mentioned earlier, we cannot afford to be blindsided by new topics or an untested format. So I urge you, please do not let this repeat in July. Either cut ties with Kaplan and revert to the previous multiple choice format, or provide extensive clarity, preparation materials well in advance that aren't corrected last minute, and full transparency on how these questions will be graded.
Thank you.
Thank you.
Our next public comment is from Edward Brookhill.
Hello and good morning. Thank you all for hearing us. I will be very quick. I was a February 2025 first-time applicant as well. It was an absolute disaster. I would ask that all of you consider going back 10 years in your mind and imagine what it was like to spend hundreds of thousands of dollars on undergrad, hundreds of thousands of dollars on law school, tens of thousands of dollars in bar prep, time off. I personally missed many, many moments with my family and friends, only to be faced with one of the worst experiences of my life. Truly. I don't have enough time to go over everything that has happened. I hope that you all are aware of the issues that individuals faced. Psychometricians are not going to be able to fix this on an individualized level because every individual had different problems. And my last comment, because it hasn't been mentioned, is that this slog is slowing down the bar's other responsibilities. My moral character application has been in effect since March 7th of last year, and I have not heard back.
Thank you for your comments.
Our next public comment is from Giselle Barami.
Hello, everyone. I'm just going to make it very quick and narrow it down to one concern that we all have. As we already know, what are the issues that they experienced in February bar, and they actually experienced this anxiety and the stress for 2 days. And I feel like for July people that were experiencing the stress and anxiety from now, which is another 2-3 months until July. And my only concern that I'm coming from a school that is hybrid, and people who are actually taking July are mostly people who actually sign up in law school when it was COVID time. So most law school went to either hybrid or online, and we've been practicing going to participating in our school mostly remotely. And my personal experience is I never been in a classroom in last 4 years to take the exam or anything like that. And the fact that all of a sudden this changed last minute just because there are some issues in February bar. And now I don't even know if I can mentally get ready for being in person and take that exam. I just urge State Bar that make this exam still remote. I mean, despite the other issues. Thank you.
Thank you, Ms. Mulroney.
Our next public comment is from Tamir Sukri.
You muted, Mr. Sucker.
Can you hear me?
We can hear you now.
Okay, thank you. Good morning, Mr. Chair and honorable members. I sat for the February 25 remote bar exam, my first attempt. During most of my essay sessions, proctors conducted ID checks and room scans after my exam started, deducting about 5 minutes from my writing time per essay. Like many others, I experienced persistent typing lag, system crashes, and disconnections, including a 30-minute lockout due to a supposed internet error, despite my connection being stable. Communication with proctors was inconsistent. I had 5 different proctors on day 1 alone, some of whom were difficult to understand, and one even inexplicably interrupted me mid-essay to recheck my ID after she had already cleared me to start, which included her checking my ID. The exam software failed to function properly, including the inability to copy and paste text in the PT. The constant disruptions had a direct impact on our performance, and they must be addressed. I respectfully request the committee to implement score adjustments using generous rubrics, consider provisional licensure for those who do not pass after the scoring adjustments are made, offer full refunds, and provide free bar prep courses for those who do not pass. Test takers dedicate months of preparation.
Thank you for your public comment.
Thank you, Mr. Sucker.
Our next public comment is from Larry Tran.
Hi, good morning. Can you hear me?
Yes, good morning.
Hi, good morning. I'm not going to rehash on the points that have been discussed by my peers before, but I'd like to go ahead and bring up some new points that I believe have not been brought up. You guys mentioned that there's going to be a retake in a few days. That would not be fair because, as you know, the California bar exam is a battle of attrition. You don't take the performance test until 6 hours into the exam. Therefore it's ultimately flawed. There's no fair way to do it. You would be mentally exhausted by the time you get to the PT. Now these people are going into the bar exam taking it at full strength, bright alert, full of caffeine. That would not be fair. I believe an equitable resolution would be a portfolio bar exam. I would also like to bring up the point that refunds, although they may seem generous, are insufficient and inadequate because, again, some people have mentioned that, the amount of money spent and the amount of time spent and the wages lost. I'd also like to make a point for us that chose not to have children because no one spoke up for us. I'm holding off on marriage. I'm holding off on having children. And, I didn't
Thank you for
decide to
your
have kids
public
before.
comment.
Thank you.
Thank you.
Our next public comment is from Andrew Noseworthy.
Yes, can you hear me okay?
We can.
I'll keep it brief. I just want to say, I do not feel like I've been granted a full and fair opportunity to take this exam. You guys took the most difficult exam in the country, and you made it 3 times as hard. Measure Learning is the worst software that's ever been created. It's going to end up costing you guys 3 times the cost. And honestly, if I find out that the state bar is using AI to create questions and to grade our essays, I'm going to lose it. So that's all I want to say. We want accountability, we want transparency, and we want reform. Thank you.
Thank you. Our next public comment is from Jennifer Adrid.
Yes, thank you for taking my comment. Side note, when asking for public comment, I've been called on and there was no, I wasn't able to unmute. So I was present, just letting you know. What I would say is which one or who of these people have actually taken this test alongside of everybody else under these circumstances. I would love for someone to sit in and take the test like one of us to see what we were going through and what July will be like. I highly recommend that you look to local universities, schools, anywhere that can support a platform that will allow test taking to occur at a less of a cost to the bar. And then also start looking at how are we putting into measures into place that are allowing for the issues that are happening within the budget shortfall to allow for an adequate testing platform to occur. Thank you.
Thank you, Jennifer.
Our next public comment is from Allie Roseborough.
Hi, good morning. Thank you all for your time. I was an examinee for the February 2025 exam, and I just want to share my deep concerns with the fairness and the integrity of this exam, specifically with the decision to award an automatic score increase to certain examinees for participating in the experimental exam. While I understand the importance of testing, exam materials, that decision to award some examinees a substantial score advantage before they even began the actual exam, that created an inherently unfair testing environment. Regardless of any technical issues or substantive mishaps on the exam, the fact that some examinees effectively started with a 40-point head start while others began at 0 placed those who were not awarded these points at a material disadvantage. And this disparity is inconsistent with the principle of a fair and standardized licensing examination. Moreover, those same examinees who were already afforded a score increase will now be subject to whatever remuneration the bar is going to give the collective of examinees. So just keep
Thank you
that.
for your public comment.
Ms. Roseborough.
Our next public comment is from Chelsea Daniel.
Hi. Hello. I just wanted to point out sometimes when you go forward and you're looking at something, you also need to look backwards. Had you given this exam and offered an opportunity, maybe a fee waiver, to take the mock exam and then offered us the original exam to kind of test out this problem, we wouldn't be here. And the fact that that wasn't done, that simple, obvious process of giving us the traditional exam and then making this an additional test that you did on top of that, giving a fee waiver to the people that agreed, that simple experiment, shows you don't respect our time, our effort, our energy, our situations, the severity of the thing that you're doing. And that shows that, these remedial measures are not going to work. Like, we need to be compensated beyond that. Like, we need to be able to work. We need to be able to refund ourselves. We need to be able to study for the test if we're going to have to take it again. We're going to need the time to replenish. So, sorry, it's short time.
Thank you for your time, Ms. Daniel.
Our next public comment is from Toya.
Hello?
Ms. Toya, you're muted. Here we go.
Hi. Oh, and it's actually Tanya. So I'm coming to you all with a bit of a different issue. I just want to say, as applicants, we've been through a baptism of fire of sorts with this exam, and our lives will never be the same. But my issue is with a breach of our privacy that inevitably has happened from taking this exam. My colleagues and I would like to know if the Measure Learning ProctorU platform is compliant with NIST 853 security standards, and what testing was conducted to validate compliance. Because since this exam, we have found our information on the dark web, and our financial stability has been compromised. So I think I speak for all of my colleagues when I say that we would like to see some remedies around credit monitoring, and things of that nature, because we have definitely been compromised, our personal information. That's all I have to say.
Thank you, Tanya.
Our next public comment is from Nadine Mazard.
Hello, my name is Nadine Mazard. I'm a first-time attorney test taker. I am licensed in 3 jurisdictions. I have passed 4 bars. One thing that hasn't been mentioned was definitely this whole process since January 17, 2025, when we took the mock exam. We basically have been candidates of intentional infliction of emotional distress. Basically, in particular, also attorney applicants at the end of all of our test taking process, we got the most severely and extreme outrageous final outcome, which we all provided with the word failed wording. So so that exacerbated the situation, made it even more where we had no idea how many essays were done, different things like that. So I do say that in addition to everything else, we need to be looking at a totality of circumstances when we're looking at essays. And for the attorney applicants, there needs to be something wherein this board, the Board of Trustees, this Board of Examiners does work something together with the State Bar to get reciprocity. And thank you to Audrey. She has been wonderful too.
Thank you for your comments.
Next public comment is from Alyssa Reyes.
Hi, can you hear me?
We can.
Great. Hello, I will make this brief. I sat for the bar exam, did the remote one, and I just wanted to share, in addition to my good quote unquote experience, I didn't have any tech issues beyond the 30-minute break. And I just want to say that those 30 minutes caused so much anxiety, so much stress, so much second guessing of my own right to be here, that I can only imagine how much it affected those who were impacted more severely. I also want to mention, I went to law school out of state, and I, like many, are retakers who were terminated when I didn't pass. I don't come from the generational wealth that my peers at the law school I attended came from, and unemployment has run out. I'm overqualified for part-time jobs and can't commit to full-time jobs because I may or may not be licensed in May. As you can imagine, debt is accruing without a reprieve in sight. So I hope that whatever happens, you guys can take that into account when you're deciding your remedies. Thanks.
Thank you, Ms. Reyes.
Our next public comment is from Dana Allen.
Good morning, and thank you for taking the time to hear us out. I guess for myself, I experienced everything else that everybody else has been mentioning. As a test taker that does get accommodations, I really had to fight for my accommodations, and that's a whole nother issue with you guys. But I also feel let down with the fact that you're supposed to be so moral, yet I feel that you were very irresponsible with the budget. And now being in this whole mess with having, it's just been a complete snowball effect. So this is a time for reform with this. And also having us take the MPRE and then also doing the PR essay as well is just not, that's not going to work either. So I think that everybody who sat for it should just get a pass, period. And as far as the whole 40 points that we were supposed to get, I think it's unfair that you made me a guinea pig without my permission.
Thank you, Ms. Allen.
Our next public comment is from Dawn Watkins. Dawn, you've been unmuted. Our next public comment is from SK.
Good morning. Like many of my fellow remote examinees, I experienced numerous delays and disruptions during the written and multiple choice portions of the February bar exam and technical issues that limited the effective completion of my performance test. With regards to the November experiment, the State Bar made a commitment to participants that they would have the opportunity for a scoring adjustment if they participated in good faith and met a minimum threshold of performance. We are still unclear as to how this will be applied to those of us who completed the February bar exam. To not honor this commitment to participants of the experiment would only further compound and not correct the challenges that were presented with the February administration of the bar exam. As someone who participated in both processes, I ask that you please honor your approved commitment of the November experiment and afford the February examinees fair remedies that reflect the unprecedented conditions that we endured as a result of the administration of this bar exam. Thank you.
3SK.
Our next public comment is from Tisha Morris.
Good morning. Can you hear me?
Yes.
Thank you so much. I was not a February. I'm a July new applicant. And my concern actually comes from the backlash of all of the experiences, but also the cost, because I know that budget is an issue. So I would like to, I guess, ask that we don't have to actually bear those costs for new applicants that will be taking the exam for the first time in July. And also the application is not even open. I am a mom of 10 children. I have sacrificed so much these 3 years, and I have put in a lot of work. And I really would like a fair chance when I do sit for the bar. I am here in California, so whether it's in person or remotely, I'm okay with it. But I just would like for it to be, fair and a system that actually works. So thank you.
Thank you, Ms. Morris.
Our next public comment is from Giovanna Meadows iPhone.
Hello, can you hear me? Hi,
Yes.
thank you for giving us the opportunity to be heard. My name is Giovanna Medell. I was wrongfully denied my time accommodations in July 2024 despite extensive documentation. As a result, I failed July 2024. I won my appeal for February 2025 based on the exact same evidence submitted in July, which proves my contention that my original denial was improper. This administration of the February 2025 exam significantly impaired all students, but especially disabled students. I am here simply to state that this California bar is an arm of the state, and so you enjoy some measure of sovereign immunity. We will never be able to hold you accountable in the way you deserve, but you can take responsibility in the way we deserve. Offer a range of remedies. Lastly, I want to echo what was said earlier about how your error is affecting communities of color and the public servants who went to law school to serve them. I do immigration law. I do not get paid much. I'm on the front lines of the greatest attack on immigrants in recent American history. I chose this, and I'm not going anywhere, but I should be doing this work with the license, and you should not get to determine my competency after failing twice to give me a fair shot at this exam.
Thank you for your time, Ms. Medell.
Our next public comment is from iPhone. User with the name iPhone, you've been unmuted.
Hello.
We can hear you.
Oh, okay, I'm sorry. Good morning, members of the Committee of Bar Examiners. My name is Arlene R., and I am speaking as a concerned member of the public. The State Bar of California exists to protect the public, and diploma privilege directly undermines that mission. The bar exam is the only objective measure of competency. The public should never have to wonder whether their attorney was simply given a license without proving their qualifications. Many pushing for diploma privilege have taken the exam multiple times and failed. This is not about fairness, it is about competency. If someone cannot pass, they should not be allowed to practice law. That is not public protection, that is a complete failure of responsibility. Yes, some test takers faced challenges in February, but not everyone was affected. Meanwhile, online discussions show that many are using this as an excuse to avoid taking the exam entirely. This committee must not allow public protection to take a back seat to applicant convenience. If provisional licensure is considered, it must require bar passage and stricter supervision rules to eliminate conflicts of interest, such as family members overseeing provisionally licensed attorneys. Otherwise, it's just diploma privilege under another name. Thank you.
Thank you for your comments, Eileen.
Our next public comment is from Farah.
Hi, I mentioned this before in the meeting from last week, but I want to reiterate that the bar should strongly consider a remedy that acknowledges the previous scores of retakers, especially those of us who came within 50 or 100 points of passing, or those who had a second read on a prior exam. Yes, we do have competency. Another fair alternative is allowing us to superscore different components from prior exams, using the sections we were actually able to complete without tech interruptions. Additionally, I cannot stress enough how bad the job market is right now. If we are forced to retake this exam, we are once again putting our careers and financial stability on hold just to study. And if we are given a provisional license, it effectively brands us with a scarlet letter. Most employers won't want to go through the trouble of hiring someone that has an uncertainty hanging over them. There needs to be a real conversation about either increasing scores across the board or reducing the passing score itself. If the board wants a deeper understanding of issues surrounding the exam, then let us submit a collective report compiling just how inconsistent and chaotic these issues were. Thank you.
Thank you, Farah.
Our next public comment is from February 2025 examinee.
Hi, good morning. I wanted to emphasize that the bar has a duty to put forward unprecedented remedies for us February examinees due to the unprecedented failure that this exam was. The bar knowingly set us up for failure by going with Mejure learning for both in-person and remote testing, which led to widespread technological problems no matter how you were taking the exam. We had connection issues where we were automatically disconnected and reconnected to the exam, which of course is distracting and not conducive to being able to type or read. The proctors told us that we were being disconnected and reconnected due to server issues at their end that they were aware of, and it was not because of any issues with our own computers. We had repeated error messages popping up and blocking our ability to see our screens, illegible text, interruptions by proctors speaking unwarranted. We need unprecedented remedies to be put forward to rectify this.
Thank you for your comments. Devin, how much time do we have left for the public comment period?
We just reached the 2 hours.
I know we have roughly, just basing on my rough counts, we have about 15 more people. Is that accurate?
Correct.
I still would like to hear from all of the individuals who have their hands raised, but also being mindful that we have a full day agenda. Would the committee be amenable to perhaps allowing maybe 5 to 10 more individuals who would like to comment?
Yes, Mr. Chair, it's Kareem. I would support that.
Okay, I see a lot of nodding heads, and so let's just give another 5 to 10 minutes allocated for the public comment period.
Okay. Our
Go
next
ahead.
public comment will be from Zoom user.
Good morning. Thank you all very much. I'm a February bar exam taker and experienced many of the issues, so I'm not going to go ahead with that. I supported California starting to become autonomous. I had no reason to question that the program and the platform that they used would provide the same level of stability and as other exams. Unfortunately, while I didn't have any reason to doubt, after going through the mock exam and seeing the catastrophic failure, I became very nervous and untrustworthy that there would be a catastrophic failure. There was a catastrophic failure. I find it unconscionable that psychometricians are being used or even considered. I see that as a remedy that is almost as flawed as knowingly giving an exam that you know is going to fail. That happened.
Thank you for your public comment.
Thank you.
Our next public comment is from Chris.
Obligatory, can you hear me?
We can.
Great. So this comment is on the potential use of psychometric analysis. As background, I was the first person to complete a JD PhD dual degree program at USC, which I did in 5.5 years, faster than anyone else in my cohort, and it was a quant-based thesis. Using a psychometric analysis is horribly misplaced, and it's also questionable that the board is even recommending this in light of earlier displays of a lack of basic mathematical competency, which suggests a lack of sufficient understanding of what this entails. First, for an analysis to be useful at all, bias must be taken into account, and we have no confidence. I have no confidence that this has been demonstrated. We've known this since the late 70s and early 80s, up to the bar's own 2023 report about bias in the bar exam. Also, there's been no information or data released about determining the question difficulty, given that the spelling and grammatical errors in the questions on the exam could have been caught by the spell checker of WordPerfect in 1985, a feature Measure was also unable to implement. I have no confidence that any kind of analysis is able to properly analyze the semantic issues or rational answer choices and the basic competency in stating the law. So 100% transparency of data and process is required. Thank you.
Thank you, Chris.
Our next public comment is from Amirha Mohammed.
Hi, my name is Lola Muhammad, and I am one that was granted accommodations. I have physical disability. Imagine typing all of these exams with one hand. But I'm a strong individual. I've been a paralegal for over 20 years, and this exam was beyond what I had ever imagined. During the mock exam, there were so many problems. So I knew it was going to be problems on the actual exam. Under the ADA, we were granted, when the California Bar granted us accommodations for more time, just because I can't use one of my hands as the other hand. There was times when I was blocked out for 20 minutes, 30 minutes. Proctor's telling me while I'm trying to type, can you go close your window? Can you do this? Can you do that? I had a proctor to tell me that I was not allowed to use my whiteboard.
Thank you for your public comment.
Thank you, Ms. Muhammad.
Our next public comment is from Salai Escobar.
Hello. Hello. Can you hear me?
We can.
Okay. Thank you so much. I appreciate the time that you're giving us to speak. I was a February 2025 remote bar exam taker, and all my peers have expressed their significant technical issues. I also experienced the same technical issues. One of the most unique ones that I experienced was that I was logged into someone else's exam while trying to access my PT because I couldn't open up my PT file and library. So I lost like 10 to 15 minutes with my PT exam. Also, being logged into someone else's exam, having to notify my proctor that that was in my exam. I don't even know how a psychometrician is able to take that into account. All the unnecessary stress and anxiety given to us test takers, wondering when or if our answers are going to save. I really hope like the bar gives a really equitable remedy to us. Thank you. I'm sorry.
Ms. Escobar.
Our next public comment is from Patricia. Patricia, you've been unmuted.
You're still muted. Here we go.
Hello?
Yes, we can hear you now.
Perfect. The California bar exam should be entirely multiple choice. This would reduce costs, grading time, and unnecessary stress while maintaining the ability to test legal reasoning. The state could implement large-scale testing centers, streamlining administration and ensuring consistency. This approach would make licensure more effective without compromising competency. Thank you.
Thank you.
Our next public comment is from DH.
Hi, good morning. The sheer incompetence and lack of integrity by all involved is astounding, and all this comes under the guise of saving money and pulling the state bar out of insolvency. We've seen no resignations, no claim of responsibility, no concessions, and no relief. How is it that examinees paid roughly $5 million or more to take the February exam, weren't provided anything we paid for, yet a free July retake is generous? Director Wilson, you should be ashamed. Also, we urge you to look past the misrepresentative and borderline fraudulent preliminary data provided by Measure. How can you rely on this data provided by a company actively in damage control and attempting to mitigate losses at this point? There's at least 2 class action lawsuits that have been removed from the contract with the state bar and so on. Psychometrics are unreliable when there are so many variables, cheating, distractions, and technical difficulties. Thank you.
Thank you.
Next public comment is from Nicole.
Hello, and thank you for your time. My name is Nicole Carrier, and I am urging the bar to return to an MBE format. For July test takers, this is a time when many of us should be focusing on law school finals and graduation, but we are plagued with the stress and anxiety and uncertainty of this California bar debacle. Many of us will be flying across the country to sit for this exam. We will be buying plane tickets, renting cars and hotels, facing jet lag, all of this. And to sit for an exam written by an incompetent entity with inequitable answers is despicable. At a time with so much uncertainty, July takers are demanding security and certainty, and reverting back to the MBE would provide that. This way, we would at least know what to expect from the exam, and we have decades worth of material to study from for the exam. Given the limited amount of time until the July bar, this is the only equitable solution. Thank you.
Thank you. I note that we have about roughly 9 additional hands. I would like to get through all of those individuals, and hopefully that would be done in 10 minutes. If the committee is so amenable to that, let's just get through, I think, the last individual, wherever it is. So Devin, if you can take a note the last individual, and so we'll run through the remaining list until the last individual.
Our next public comment is from Nicole. Nicole, you've been unmuted.
Devin, I think Nicole actually just went. So I think we're on the next one. Thank you.
Our next public comment is from Anna. I think you've tried to unmute before. If you want to try again.
Good morning. Can you hear me?
We can.
I hear you now, yes.
Good morning. Thank you for your time. My name is Ivana Carballido, and I'm a foreign educated attorney who sat for the February exam in person. I'd like to begin by acknowledging that this exam is fundamentally flawed. I dedicated months of intense preparation after burning out day after day. For me, withdrawing from this exam was never an option. Time and financial resources were on the line. So when my computer crashed during the exam for over 30 minutes and the proctors couldn't confirm if I'll be able to continue, I had a panic attack. I want to be clear. I categorically reject the scoring adjustments by the psychometrician. This will not address the real issues faced by many of us. Furthermore, it's clear that one-size-fits-all remedy simply won't work. The only viable temporary solution to the hardships we face is to grant provisional licenses. Additionally, refunds should be provided, which could be used for bar prep courses for July. Finally, reciprocity for attorneys licensed in another jurisdictions could help address the unique challenges we face. We urge you to make things right. Do not let these happen again in July. Thank you.
Thank you.
Our next public comment is from Priyanka.
Hi, can you hear me?
We can.
Yeah, I'm a February 2025 bar taker, foreign attorney from India, and I have a 14-month-old baby. I signed up for the experimental bar test in November, and before signing up, I changed my email address, and I did not get the opportunity to take the experimental bar in November because I wasn't given the new in the new email address. So I missed taking that exam. So that was a flaw, not from my end. And then of course I faced a lot of problems when I took the test in last month in February. I had day 1, day 2 issues. I got a response from our on the day 1, but I got no response from you guys when I emailed on the day 2 issue I faced. I had a 20-minute error on the last 40 MBs, and it just affected my entire performance. So wanted to get an update on that. Thank you.
Thank you.
Our next public comment is from Beek.
Hi, good morning. So I'm an attorney applicant, and I just want to say that the bar exam does not only affect to the applicants, but also to their families. I have 3 kids, and the applicants had to stop our lives, neglect our kids, and suffer financial difficulties just to be able to sit for the bar, which will be normal in normal circumstances, but not for this bar exam. Some people, other applicants already mentioned that they had to spend all the money from their village just to be able to sit for the bar. I personally had to put 6 years of salary to be able to sit for the bar. So making applicants to repeat the bar exam, it's just punishing them for the negligence of the bar. That's not the first solution. The only solution we agree is to having provisional licenses subjects not to take the bar exam, but to practice under supervision or doing pro bono work. This is the only solution where all the applicants agree. And that's it. Thank you.
Thank you for your time.
Our next public comment is from Mercedes.
Good morning. Can you hear me?
We can.
Thank you. Okay. So just to go over some remedies that I've kind of thought of and proposed, given that no 2 test takers really took the same exam and everyone experienced several problems and different problems at different times. With that being said, the remedies that I've proposed in theory should be taken as a whole. So the first part is to lower the passing score to 1340 based off of the precedent set for the July or October 2020 exam. Second part is to grade only 4 essays. This is based off of the bar's reasoning to allow people to retake the exam. And then to adjust the PT scoring. So you would grade the PT as if it had been administered under expected conditions, and then multiply that grade by 3. And the rationale in that is that people were really only able to perform a fraction of what they otherwise would have been able to. Grade only 150 of the multiple choice questions. And
thank you for your public comment.
Okay. Thank you.
Thank you, Mercedes.
Our next public comment is from Sam Elias. Sam, you've been unmuted. Our next public comment is from Leslie Estrada Flynn.
Hi, good morning. I just wanted to share my experience. I am a retaker and took the July 2024 exam. I just wanted to say that the anxiety of having to wait to make plans to book a location for the bar exam was incredibly stressful as an accommodations taker. And I found it incredibly frustrating, especially after finding out that the state bars didn't even consider accommodations takers when first booking the locations. Additionally, I took my exam at San Jose State with accommodations. The computer setup was incredibly uncomfortable. The monitors were set up underneath glass. Reflection was an issue, causing me to hunch over for hours at a time, causing extreme back pain and wrist pain just from trying to keep my hand underneath the glass. The myriad of problems that we were experiencing, starting 45 minutes late, the proctors couldn't log themselves on. We just urge you to lower the passing score so that we could pass. Thank you.
Thank you, Ms. Flynn.
Our last public comment will be from D. Nicole.
Hello, can you hear me?
Yes.
We can.
Hi, good morning, everyone. I sat for the February 2025 bar, and I experienced all the issues that everyone has stated, and specifically with the MBE. On this day, I could not get started at all. I literally spent all day trying to get started. I was transferred through at least 20 proctors. I want to give a shout out to Tara Clark, who was with me through all of this. She stayed on the phone with me all day. She knows firsthand what I went through. And I just want to highlight that I am a provisionally licensed lawyer from the original 2020 group. I've been in practice for almost 5 years. I've second chaired trials. I actually had to reschedule a trial that I was scheduled to be a part of just to take this exam. Now I'm doing a disservice to my clients, and I just want, as you consider remedies, to consider the people who have already been provisionally licensed and have been practicing law for almost 5 years. I mean, this exam was a nightmare. And with the provisional license program ending at the end of this year, it's unfortunate.
Thank you, Ms. Nicole. And thank you, Devin, and thank you, Tara, for helping the applicants. With Ms. Nicole being the last individual, I just wanted to say thank you for all your comments. I'm personally very moved by all the comments we have received today, and this committee will do everything we have in our power to provide just and fair relief to all those who have been adversely impacted. Now we will transition to closed session for 30 minutes. Right now I have 10:30. We'll back up on around roughly 11 o'clock. So for those who are still with us, please hang tight. We'll be back shortly and resume the open session so that you can continue to participate in this meeting.
Mr. Chair, it's 11:30 a.m.
Oh, I'm sorry. I have my time difference mixed up. Thank you for clarifying. So we'll be back at noon.
Everyone
for the
should have
vote.
gotten the closed link from me, so look for that.
Yes, and to my colleagues, you can now leave the open session and join the closed session using the link that Audrey sent out. Thank you. For the public, we'll resume our open session as soon as our coordinator is ready to take roll. Hey, Devin.
Hi.
Welcome back.
Thank
Okay,
you.
I think we're ready. Thank you. Please go and take roll.
Dr. Bolton,
LA office, you muted.
the actual room is muted. Dr. Bolton,
Here.
Dr. Cao,
Here.
Alex Chan,
Here.
Kareem Gangora,
Here.
Larry Kaplan, Larry Kaplan,
Here.
Paul Kramer,
Here.
Alex Lawrence,
Here.
Esther Lynn,
Here.
Justice Misiwala,
Here.
Bethany Peak,
Here.
Ashley Silva Guzman,
Here.
Judge Reyna,
Here.
Vince Reyes,
Here.
Alan Yokelson.
Here.
We have a quorum.
Thank you, Devin. We're now back from the closed session. Thank you, everyone, for your patience. Exercising my authority as the chair, I've now asked the staff to reshuffle the order of our agenda so that we can attend to the most important items first today, beginning with item 4.1, followed by item 4.2 regarding the February 2025 and July 2025 bar exams. Donna, I believe you and Chad, as well as Audrey, have a report for us, so please take it away.
Yes, Devin, if you could share the slide deck.
Let's
Yeah.
and promote Chad 1 second. And I think Chad is going to share his own slides.
Okay, Chad's been promoted, and then let me pull up the PowerPoint.
Chad's sharing his slides, Devin.
Just checking. Sorry, Devin, can you see those?
I can. Thank you.
Yeah.
Okay, great. Thanks, Alex and members of the committee. As discussed or implemented, what we're talking about today are some of the preliminary results from the data analysis of the multiple choice portion of the examination. The grading processes for essay and PT questions are separate. We don't have data for that yet to be able to evaluate. So I'm going to share some information from the examination and then invite questions from the committee. As a reminder, this is probably a slide that the committee is getting tired of seeing from me. The steps in development and validation of process for an examination align with the standards for educational and psychological testing, which again is kind of the guidelines for test development and validation. In terms of the steps taken to develop the examination, that first step, confirming the exam blueprint, developing and reviewing new questions is a continuous process. There was a pilot test sample of questions from the November experiment by which we evaluated the multiple choice questions essentially for capacity to potentially support scores and decisions for the examination, and then actually building the exam forms from that, culminating in administration of the exam. Although the bulk of administration occurred a couple weeks ago, this step is noted as in progress, recognizing that additional administration is still occurring. Similarly, analysis of applicant data produced for the multiple choice questions and other questions for the exam are in progress, and determining the raw passing score to associate with the scaled score is also something that is in progress. So what I'll be sharing is information about some of the key steps in validation to get us to the data. So that first critical step, qualitatively in terms of development, new questions were drafted relative to the exam blueprint or the content map that the State Bar has published. There was editing for style and structure, and then qualified external reviewers that were not affiliated with developers were asked to come in and review those questions. And by qualified, we're talking about individuals who have familiarity with both the content and the target population of applicants who are taking the examination. So they were asked to review the draft questions for a number of characteristics, one being the content accuracy, second being the cognitive complexity, meaning the sort of depth of knowledge expected by an entry-level applicant. They also reviewed questions for bias, diversity, and inclusiveness, and also to ensure that they were targeting an appropriate level, specifically that we wanted all content to target what would be expected of a minimally competent applicant. So those were requirements of all the questions that were then put forward as eligible to be considered for a form for the examination. In terms of the analysis, again, this is a summary. The February exam was administered in person and online, and we recognize that online means that there are a number of different conditions of online, whether that means small test center, large pop-up center from a home location or some other location, in addition to the 117 handwriting applicants. And so the data you're going to see today is going to be shown in aggregate. We are again in process of analyzing for different conditions, and so what you'll see now is information that is based on kind of the total number of applicants taking the multiple choice questions, and then we can respond to questions related to that. Yes.
Before you proceed, if I could just interject for a second. There were some comments that were that we had heard about people who had expertise in bar prep not being included in some of those panels that reviewed the questions. And so I just wanted to note that that there was a determination where we our general counsel's office had identified that people with certain conflicts of interest or who potentially could have essentially people with certain conflicts of interest who had certain relationships were not appropriate to participate in those meetings, and that's why there were individuals who we asked, whether you have this particular conflict of interest or relationship to materials that could pose problems. That's why those individuals did have to be excluded. And so I wanted to mention that because that was discussed in some of the public comment.
Could you describe any more specifically the nature of these conflicts?
So perhaps we can turn that over to our Office of General Counsel.
Sure. So, Paul, I understand the question to be what kinds of conflicts might have excluded folks from participating. Is that correct?
Yes.
Yes. So individuals who might have personal conflicts of interest that would not enable them to give disinterested feedback. Another issue was to ensure that people did not have access to intellectual property that could compromise the question. So those were some of the criteria that were utilized in identifying who was able to participate.
Thank you.
Should I keep going, Donna?
Yes, please.
Okay, thanks. And so with those questions, what we're looking for in terms of evaluating the questions themselves statistically are a series of calculations to determine whether or not the questions kind of fall within the normal range of characteristics that we would expect of questions on a licensing examination. And so the key ones that I'll share with the group are item difficulty, which means how easy or difficult the question was empirically for the applicants or the participants. And our goal for this, we're looking for values of 0.30 to 0.80. And if you think about those decimals as corresponding to a percentage, what this means is we are essentially looking for questions in which somewhere between about 30% to 80% of people get the questions correct. And I'll talk about why that range is kind of used when I provide the summary information for that. Item discrimination. Item discrimination is calculated using a statistic called a point biserial correlation, in which we are looking at the relationship between a score on an individual question and then a total score on the examination. The goal here is that we have positive values. So anything above 0, correlations range from -1 to +1. And so each one of those questions that has a value above 0 has the chance to contribute a little bit. And we want the items to contribute to reliability. And so we want those values to typically be higher than at least 0.10, ideally higher, but again, is sort of a threshold. In addition, we look at something called an option analysis. This is where we are looking at not only the keyed response, so the correct response to the question, but we're also looking for each distractor in the question being plausible. Plausibility of a distractor means that they represent common misperceptions or misunderstandings of the particular concept being tested in the question. And so what we want to see for that is, are each of the response options, and in particular the distractors, getting endorsement or being chosen by at least 5% of applicants taking it. If it's fewer than 5%, we can attribute that to reasons other than that being considered a plausible distractor for purposes of the question. And then finally, we're looking at internal consistency reliability. Internal consistency is an estimate essentially of how well the items on the test are intercorrelated with one another. And again, because it is a correlation, these values range from -1 to +1. Positive numbers are almost a baseline expectation, and we really want to have values above 0.80. We want to be very confident that the scores provide some value in terms of making decisions than if we're going to make decisions with those scores. And so what we're looking at with internal consistency reliability is the common statistic is coefficient alpha. And so I'll explain that in a little bit, as well as some things characteristic of that. And again, these are goals. So when we're looking at a form of the test, we want to see that most of the information meets these goals. And if it doesn't, that provides formative information for revising questions or adding new questions to the pool. Like this is very common in test development, that you're going through multiple iterations of drafting items, getting data from them, and then using that information in order to improve upon those items over time. So for the additional information, I think that's important just before showing some of the summary statistics, is that responses for one of the questions in the KES number there is just an item identifier. They were not recorded for the online administration. So the only data we had for that particular question was coming from our handwriters. And that sample was not only too small, but unrepresentative of the full applicant population. And so that question was removed from scoring. Other questions were flagged for revision or removal. This is a common thing within testing, that if questions either don't meet those statistics, or worse, if some of the questions actually function in an opposite way from what you expect, you remove those from scoring, or you flag those for future revision and improvement of the questions. 35 questions administered on the November experimental exam were embedded among the 200 multiple choice questions administered in February, in part to evaluate item drift. Item drift is when we're looking at the change in performance of item statistics from one administration to the next. Notably, 4 examinations that use equating, which many large-scale, higher stakes exams do, the use of equating items, or a common item equating block, is very common. And so you will see a proportion of examination questions frequently showing up across multiple versions or administrations of the test, which is why test security is such a critical factor, so that future examinees or applicants don't have advantage to information from the exam that would measure something other than their ability within the concepts. As planned with the administration, 175 of the 200 questions were selected for scoring. There were 2 criteria that were used in order to determine which questions would be the ones that were scored. One was we had to meet the content map, meaning there needed to be 25 scored questions for each of the 7 subject areas. And then we wanted them to exhibit acceptable statistical performance. And so in some cases, questions may have had a lower item discrimination than desirable, but for content reasons needed to be kept. Those lower item discrimination values were still positive, but didn't contribute as much as maybe some other questions. Similarly, some other questions that were either considered too easy or too difficult were also retained on the examination for scoring in order to meet the content specifications, to ensure that those 175 questions represented the content as was published in the content map and the test design. So as we move then to the sort of summary of item difficulty, and again, the way we interpret this is that each question is scored as correct or incorrect, and the statistical value calculated here is the proportion of applicants who answered the question correctly. And so if you look at that difficulty range and see 0.81 to 1.00, this is telling you that 33 questions had percent correct of 81% to 100% correct. Generally, these items are considered fairly easy. And so they don't contribute as much information in helping us to distinguish between that threshold between the minimally competent applicant versus individuals who are not yet designated as minimally competent on that threshold. And so because of this, items that are too easy are often flagged and sent back for revision, or they're potentially discarded. And so these are questions that that will be flagged and evaluated for sort of future utility. You'll see that most of the questions did fall between that range of 0.3 to 0.8. Many of them falling between about 0.5 to 0.8. And then we did have 7 questions out of the 175 that were considered more difficult than our target threshold of at least 0.3. And so this is telling you that of those 175 questions, there were some that were too difficult, some that were too easy. In this case, the easier ones seem to outweigh the difficult ones by 4 to 1. And again, I think it's an important point to mention here that that these are in aggregate. And so some of the additional disaggregation analyses that we run to evaluate what we would expect these items to perform in future is we will disaggregate analyses by first-time takers versus repeat takers. In addition to any of the other sorts of data analyses that may occur to ensure that the item characteristics can be considered stable over time. Moving on to the item discrimination summary. So again, item discrimination was calculated here based on a point by serial correlation. That means that each of the questions were considered what was the relationship between performance on an individual question and then a total score based out of the 175 scored items that were designated as mentioned earlier. So our goal here again is to have positive values because values that are positive and the stronger they are, the more that they contribute to our estimate of score reliability, that internal consistency value that I mentioned. We can see that most of these values fall between 0.1 and 0.4. Anything getting above 0.4 is somewhat unusual to see anyway. So I guess I wasn't surprised by seeing that particular number being small. Most of the items, again, falling between somewhere between 0.1 and 0.4 is a positive characteristic of saying that these items are providing a sort of predictive power as to whether or not somebody scores higher on the test versus lower on the test. Again, questions that have that sort of positive relationship, it's important to note that if there were a negative relationship, what that would mean is that by somebody getting the question right, we would then predict that they would actually score lower on the test. And so that's why it's really important for these values to be positive and as strong as possible. But negative values mean that there is something wrong with the item, that it could be miskeyed, it could have multiple correct answers. There are a variety of reasons as to why a question may exhibit a negative point by serial correlation. Those are flagged and again, forwarded to a content committee for revision or elimination if it can't be fixed. Moving on then to our response option analysis. The option functionality, as I mentioned earlier, we want all 4 of the response options, so A, B, C, and D in a kind of a typical multiple choice question. We want each of those to have at least 5% or higher. Obviously, the keyed response, the correct response, we've already established earlier, that should be at least 0.3 or higher. And so we expect a large number of people to answer those questions correctly. But we also want those distractors, the plausible but incorrect values that represent common misperceptions or misunderstandings. We also want those to basically be attractive enough that people who do not understand the concept that's being measured in the question at a deep enough level, we want those distractors to also function. And you'll see that it's a 4-option response. But the reason that there's sort of flexibility to say 3 or 4 of the response options is that we know that from some longstanding research that as long as we have at least 2 really good distractors, then we can the test will still the question can still kind of overcome having one one of the distractors not work as well. So you can see that for most, so for 124 out of those 175 questions, 3 or 4 of the options functioned kind of as expected. In 44 cases, only 2 of the response options functioned well. Now, you might say like, oh, 44, that's almost the number of the too easy and too difficult questions. That's usually an indicator that if the question is too difficult, or if it's too easy, particularly if it's too easy, then most people are responding to only one of the response options. So not surprisingly, you're not going to see a distribution among the other options. And in a few cases that there was only one sort of functioning, that again could be an indicator of a question that is too easy or a question that is too difficult. And again, these become flags that are sent back to content advisory committees in order to review, revise, or potentially rescind from use. So what I've described so far are item level analyses. And so when we think about looking at individual item questions, we're looking at these statistical properties. When we aggregate and look at the 175 questions that are scored in total, how do they function as a form of the test? One of these statistics that we'll look at is internal consistency. And again, sometimes people will generically call this reliability, but specifically for multiple choice questions, we like to specify that it's internal consistency because for other types of measurement, different sources of measurement error may be more important to identify. So for multiple choice questions, we're often using coefficient alpha, which essentially is just estimating the average split half reliability of all possible combinations. This is looking at the inner correlations of performance of those questions to determine whether or not how you perform on one is then predicting how well you're going to score overall or how well you might perform on other items. We're looking for consistency of performance there. Our goal for making individual decisions, a lower threshold is typically about 0.80. So we want something higher than that. If for folks who participated in the December CBE meeting, the predicted reliability based on our November experiment was 0.82. So we had 49 questions from the November experiment. We were able to use something called the Spearman-Brown prophecy formula to project forward to say, if we had similar questions like this, what would it look like on a full-length version of 175 questions? Our prediction was 0.82. The actual reliability based on those questions was actually 0.90, so a little higher than expected. So that means that we underestimated a little bit based on the November experiment. Let's see. We can also use the Spearman-Brown prophecy formula, though, for other reasons. So in terms of internal consistency, as I mentioned, that lower threshold is usually about 0.80 when we think about wanting to have confidence in the score. And so we can use Spearman-Brown to also say, if we were to reduce the length of the exam to, let's say, 140 scored questions, this would be a 20% reduction, where we would have 20 questions for each of the subject area. The predicted reliability for that would be 0.87. Now, Spearman-Brown makes the assumption that if you're using questions that essentially have some of the similar characteristics as you had for the full-length test, by how much would you need to increase it or decrease it to achieve an estimated reliability value? And so I put these in here just as almost for future planning or future strategy purposes. You may be able to reduce the length of the exam and still have an acceptable reliability. Similarly, you could even potentially reduce the exam to 105 questions and achieve an internal consistency reliability of 0.84. Notably, as I mentioned, when you saw the item difficulty values of having 33 questions that were probably too easy, 7 questions that were too difficult, those questions are likely not contributing much to reliability. And so in a way, what this is telling you is if those questions didn't function well, but with our 175 questions, we achieved a pretty strong reliability estimate. It's really saying that a lot of the lift of helping you make decisions on the multiple choice portion are coming from about 100, would it be about 130, 135 questions. And so that gives you some potential flexibility or degrees of freedom to be able to, in the future, consider different strategies for a future exam. Obviously, some of these strategies, are for future discussion, but there are obviously multiple linear forms of the examination. Right now, California administers an exam in a linear fashion, meaning everybody takes the same fixed length form of the test. Questions are randomized in order to, again, protect some of the security. There's something called linear on the fly testing, in which linear forms of the exam are constructed so that everybody is taking the same number of questions, and the content map or blueprint is achieved for everybody. But in addition, the statistical properties of each of those exams that are constructed are designed to be equivalent so that everybody has essentially the same difficulty of the test. Nobody's getting the hard version of the test versus the easy version of the test. And then finally, there are different methodologies for adaptive testing, in which the questions that you get are going to change dynamically based on how you respond to prior questions. There are examples of examinations. I suppose the NCLEX nursing licensure exam is one of the larger examples of this, in which how you answer the question dictates the next question that you're getting. In the example of the NCLEX, they do use a variable length stopping rule so that the exam can be, there's an upper and lower bound of how long that exam is going to be based on how you respond. And so, again, I mention all of this only to say that the questions, again, in aggregate, functioned well, and most of them fell kind of within the target goals that the state bar has set for what the expected sort of question range they may want to see. This is really more to think about what sort of future opportunities are there for the multiple choice component of your examination. And with that, I guess I'll invite any questions.
Is that Justice Messawella? Go ahead.
Yes. So from what I was reading in the written comments and the ones that I heard today orally, what I think is that the February bar exam was unacceptable, how it was administered. And so my question to you is, how do we apply a psychometric analysis to a bar exam that had the procedural flaws that we heard about today and read about in the written comments?
Well, I appreciate the question, and I think we are actually in part of the discussion will be then sort of how to, like, what steps can be taken to respond to this. At this point, it's just kind of, as I said, in aggregate. One of the initial steps that would be important in responding would be to disaggregate those data by the different types and severity of disruptions that occurred, in order to then try to equalize or determine the sort of potential effect on these different groups of applicants, because the disruptions, that investigation is ongoing. So I don't necessarily know how many different sort of categories or classifications of disruptions or would occur to be able to say, here's exactly what the next steps would be.
But if I may, we are, as we proceed through this presentation, we're only sort of a third of the way through, I would say. we are going to be talking about sort of the possible remedies, as well as just a panoply of different types of things psychometrically that can be done to deal with what may be referred to as disruptions or technological challenges, or the types of things that we have heard from our test takers. So we are going to be getting into that a little bit more in just a few minutes.
San Francisco?
Is that Paul, San Francisco?
Yes.
Go ahead.
So the 25 questions that were removed from grading, if you can make a generalization about them, were they mostly too easy, too hard, or was it a lack of distractions, or just was it all over the place? The reasons for taking them off.
Yes, great question. I would say that like to generalize, most of them had really, really poor item discrimination characteristics. And some of that is driven by it being too easy or too difficult, but largely I would say the 25 questions that were unscored would have had a negative effect on reliability.
Thanks.
I see another hand there. Is that Vince? Ashley, go ahead.
Great, thank you. So were the 25 questions that were removed kind of a standard? We removed 25 every exam, or was it something where that was the amount of questions that was not meeting the standards, and if there had been more, we would have removed more?
Good question. So the sort of published design for the exam is that there's 175 scored questions, 25 each. And I think the thing about the examination is, had there been more questions that like performed egregiously, that would have had a negative effect on applicants, then I think it would have been within the CBEs or your purview to remove more of those questions. A question that is too easy or too difficult by itself doesn't necessarily negate its representation of content. I think when we start to see negative point by serial correlations, that then kind of says, hey, this is a question that is not functioning as expected, and we don't want it to negatively affect reliability or potentially applicants.
And so if we had needed to remove more than the 25, is it safe to say it would have started to affect the deviations that we saw in those other numbers? We would have been starting to fall out of those positive ranges we wanted to see?
Actually, no.
Okay.
So interesting. That's a great question, Ashley. Because if you think about it, because we had those 33 questions that were too easy, 7 that were too difficult, had we removed those, it is likely that I kind of showed that with that one Spearman-Brown estimate, that if you only had 140 questions, your reliability still would have been 0.87, which is pretty good. And so yeah, you could have removed additional questions if necessary. It would have been uneven then in terms of the content representation, but it wouldn't have had a dramatic effect on the reliability.
Anything further of Chad?
So yeah, if I may, Mr. Chair, I wanted to circle back for just a second on the conflict issues and the intellectual property concerns that guided the screening for who should have been involved in the standard validation panels. And then I wanted to ask Chad to elaborate on a point that he made, and so I'll get there in just a second. So just so there's sort of clear understanding, the screening criteria that had been developed to address conflicts and the intellectual property concerns, starting with the conflicts, we wanted to screen out as panelists for this standard validation, panelists who had immediate family members who had taken the February bar exam, panelists who had a close personal relationship with someone who had taken the February bar exam, And then sort of on the intellectual property side of things, screening out panelists who performed work, whether paid or volunteer work, or had an independent contractor relationship with the National Conference of Bar Examiners at any time since February 2024, including work relating to the next gen exam. Panelists who had a license agreement with the National Conference of Bar Examiners relating to the use of NCBE's intellectual property, and panelists who had accessed, referred to, or used any NCBE exam questions or exam questions from any bar prep companies within the last 6 months. So those are the criteria that were looked at for determining who were the right candidates for, or who weren't the right candidates, I guess, for the standard validation. But Chad, I was also hoping you could elaborate a little bit more on, you had talked about wanting, I think your words were, wanting to use people who were sort of closer in time, or closer to sort of understanding what what a minimally competent applicant would be. And so if you could talk just for a brief moment about, were we looking in the standard validation process for subject matter experts, which is one of the things that we're hearing, or were we looking more for recent bar takers, recent bar passers, et cetera? If you could sort of highlight what the primary criteria are for participation in a standard validation panel like we had.
Yeah, Donna, thanks. And yeah, within the testing community, we use the phrase or the term subject matter expert, and then we shorten it to SME. We use that very generically to refer to panelists who are contributing their content, knowledge, and experience to a committee, whether it's an item review committee, whether it is a standard setting committee or a standard validation committee. In the case of the standard validation study, as Donna was, I think, alluding to, is that in terms of individuals who would be eligible to sit on that committee, we want people who they should have the subject matter knowledge. So in order to make judgments about what would be the likely performance of a minimally competent applicant sitting for the bar exam, you have to have subject matter knowledge. You can't be absent that content knowledge. But we also want representation, usually from kind of 3 key stakeholder groups, because they each provide a slightly different perspective of what that expectation is. One group is we like having faculty members from training programs, particularly if they're working with individuals who are about to take the bar examination. Because again, they have a familiarity of where those applicants are sort of in that process. The second group is going to be individuals who are essentially recently admitted to the bar, meaning they have taken and passed the bar within the last few years, and so they are close enough to entry-level practice to also understand what is the sort of a reasonable expectation for a minimally competent applicant at that point of entry to practice across across these different subject areas, regardless of their chosen practice area or areas. And then I think that third group that's really helpful is by having some licensed and practicing attorneys who supervise entry-level members to the bar. So again, you have individuals who they have that content knowledge, but they're also aware of what those initially licensed attorneys know and are able to do, so that they can make reasonable judgments about what's a reasonable expectation for a minimally competent applicant. And I think again, that key phrasing is regardless of practice area, because when you're sitting for the bar exam, what is that sort of expectation across all of these subject areas versus somebody who has perhaps only practiced in 2 or 3 areas for most of their career. Their depth of knowledge is obviously going to be much greater than somebody who is at that point of sort of entry to practice.
Okay, are there any other questions or comments? Donna?
Yes, I have a question.
Oh, I'm sorry, Dr. Bolden?
I'd like for him to describe or demonstrate one of his analysis processes.
Chad, did you get that?
The request was to demonstrate one of the analyses processes?
Yes.
Is that something you can do, Chad?
Not on the fly. I mean, if given the opportunity, I'd happily pull up an Excel spreadsheet and we could start doing some calculations. But I don't know that I'm not actually prepared to do kind of a live analysis right now.
Okay.
All right.
Dr. Bolden, would it be okay? I'd like to see that demonstration, but I don't think we have time for that today. But let's put that on for a future, something to talk about in the future in a training session. Is there anything else? Donna, did you want to move on then?
Yes.
With your report?
So yes, and we're still in item 4.1. And now if I can ask Devin to put up the slide deck. And if you can put that in presentation mode.
Are you seeing it okay?
No, if you can put it in presentation mode, we see the thumbnails on the left.
There we go.
Let's see.
I'm going to get started while Devin is doing that. I wanted to, I realized that I've been talking at the Board of Trustees meeting a couple of weeks ago. I've been talking a little bit here today, and I wanted to take the opportunity to reintroduce myself to the committee. I don't think we've had a change in membership since I was last involved in the admission space, but I did step away from the admission space for a year. I had been the chief of programs for about 6 years, and admissions was one of the programs under my purview. But as of February of 2024, I had stepped away from admissions. As we were dealing with some of the issues with regard to the February 2025 bar exam, it was determined that, like the Office of Chief Trial Counsel has a chief sort of over the discipline function, and the admissions function is equally important to the work of the bar, and that we needed to elevate the work of admissions by having a chief that was specifically just over the admissions process. And so I have effective February 24th, the day before the bar exam, I was officially put into the role of the chief of admissions. And I'm back with you now today in that capacity. I did also want to start my presentation today by echoing some of the words that Alex Chan made, echoing some of the sentiment that Justice Masuala had indicated, and that several of our board members, and I know many of you on this committee, feel that we are all incredibly disturbed by what happened with the administration of the February exam, both the technological and the human failings. It was unacceptable. And I fear that sounds hollow when I say it, but we do want to make sure that the applicants know that we have heard them. And there will be investigations into what happened, so that things like that never happen again. With that, Devin, why don't you go ahead and advance the slides? As a way for you all to be thoughtful about the next steps, this presentation is intended to give the committee some facts about what we've heard and what we know to date. So let's take a quick look at the numbers. Didn't realize I was not going to be able to see the screen from this far away. So taking a quick look at the numbers, there were about 300 people who were scheduled to take the exam. About 2/3 of them remote and 1/3 in person. 352 of that overall number were scheduled to take the one-day attorney's exam. We had 132 handwriters that were scheduled. Overall, just nearly 4,200 attended the exam. And there were also, as you see, about 133 no-shows. We had in total 1,346 withdrawals. The vast majority of those, over 1,000 of those withdrawals, happened after we had announced on February 13, I believe, that even though it was long past the deadline, if people wanted to withdraw from the exam at that point, as a result of the difficulties that they were reporting, that we would offer a full refund. So that's sort of just to set the context. Let's talk a little bit about what, I'm sorry, Devin, if you could advance the slide. Turn now about what we've learned so far from our bar exam vendor, Measure Learning. Next slide, please. So first, just sort of what are the inputs that we have? We have preliminary data that we derived based on the applicants who took the exam on the Measure Learning platform, and we'll be talking about that data in a little bit. The data includes things like test taker start time and end time for each session. It included an analysis of who had written, who had content on any of the written components, the 5 essays and the 1 performance test. We received some additional detailed data, and that is pending review at this time. So let us take a look at the input that we received from test takers. Devin, if you could advance the slide. As you know, we've had significant input from test takers, whether in the form of public comment here, public comment at the Board of Trustees meeting. Advance the slide, please. Escalations to Measure Learning technicians during the exam itself, calls to the state bar during and after the exam, emails from test takers to the state bar during and after the exam. As well, there were state bar representatives at select test centers, and there were communications with from test takers to our staff who were at those test centers. So you've heard a lot. Next slide, please. You've heard a lot about these issues that the test takers have reported. I think it is worth mentioning them again, however, and this is, as you see from the sort of title here of the slide, these are the types of issues reported. This is not purporting to be a list of 100% of the issues that we've heard about. Some test takers experience an inability to launch the exam at all, despite, in some instances, often hours working with technical support to try and get into the exam. Others talked about frequent disconnections from the exam, the system crashing, being disconnected, saying that they no longer had a connection and had to get reconnected to the exam to continue. Hours of tech support in order to get back to testing. Many test takers have reported about the fact that the clock was running for some of them while they were trying to resolve some of their technological issues. We had both the inconsistent issue of unexpected submission of answers where they were being submitted before the applicant was ready to have them submitted, sometimes automatically submitted answers. And at the other side of that spectrum, there were applicants who faced an inability to submit their answer and spent much time with technical support or with our staff trying to get their answers submitted before they could proceed to the next question. There were also significant delays in starting the exam at test centers, and this was in particular on day 2 of the exams, where the test centers experienced significant start delays. There were also, as you have heard, a number of issues with the functionality and the system just not performing as expected. Things like the cut and paste not consistently functioning, for some perhaps not functioning at all. The screen freezing and time continuing to run while the screen was frozen and the test takers were unable to proceed to answer the questions. There were lags where typed answers didn't appear on the screen for some small period of time after they typed, and the converse where applicants deleted portions of their answer, and there was a lag before the text deleted from their screens. There were reports of problems with highlighting. There were reports from some of the PT file and library not being available either at all for 20 minutes into their session or for some other period of time. Next slide. So those were some of the technological issues. If we look to some of the, on the human side, some of the challenges of what has been reported include proctors and technical support being unable to resolve problems that test takers were facing, incorrect information from proctors or support. There was disruption by proctors to reconduct the security scan or to request individuals to adjust their seating or camera position. The frequent switching of proctors, and as a result, having the new proctor ask for information that was maybe fine, ask for a rescan because there was something they saw in the back of the room that the prior proctor did not have a problem with. There were reports of unprofessional or rude behavior from proctors and support. Next slide, please. So between these sort of two different sets of inputs, the data that we have from Measure Learning and what we've heard from the applicants, now is the time to ask sort of what do we know or what do we think we know about what went on. Next slide, please. So the more I think about it, the more I realize that the two different inputs aren't necessarily providing us with inconsistent information. It's that they're measuring different things. The data is painting a picture of a high number of test takers being able to submit their responses to the written components or being able to respond to a high percentage of the multiple choice questions. But we know that that's only part of the picture. Whether you were able to submit your answer or answer the multiple choice questions, the test takers are telling us that that is not an assessment of quality. The test takers are telling us that they did not have the ability to demonstrate to the fullest extent of their ability what they know. That the technology, in fact, hindered the quality of their submissions or their ability to demonstrate minimum competence. So we do have sort of these two facts which seem to be telling a different story, and I think it is because they are measuring different things. But let's go ahead and take a look at what we do know about the performance, looking at the data itself on starting with the essay and the performance test. Next slide, please. These numbers are from the preliminary data that we had received, where we're looking at about 4,100 applicants who were using the Measure Learning platform. So that doesn't include applicants who were handwriting the exam, whether as a request or as part of an accommodation. Of those applicants, about 98% had some content on all of the written components. Another 1.3% had content on 4 or 5 of the written components, and fewer than 1% had no content on 3 or more of the components. Next slide. We can look at the performance in the same manner about the multiple choice questions. There were 12 test takers who were using the Measure Learning platform who were unable to complete any multiple choice questions at all due to technological issues. 20 who failed to complete more than one of the 4 multiple choice questions. Of the remaining, about 98% submitted answers to at least 195 of the full set of 200 questions. Next slide. So as I said, and as you've heard from the test takers, the data doesn't tell us about the quality of the exams that were submitted. Right, the data says there was some content on the written content on some of those submissions, but doesn't tell us whether the applicants were really able to demonstrate their ability. So I wanted to talk a little bit about some of the efforts that we have started to engage in to try and identify impacts on quality. One was a random, we selected a random sample of test takers who had written content on all 6 of the 6 written components, the 5 essays and the performance test. And we reviewed the random sample to assess the response quality and anomalies. We also surveyed test takers. A survey was issued to all test takers on March the 4th. We just received those results of the survey. I have not had an opportunity to do much of a review of the data, but what I can tell you is this. We had a 66% response rate to the survey. 63% of the survey respondents completed the entire survey. That is a very high response rate for these post-bar exam surveys. And that in and of itself, I think, indicates to the committee the strong interest that test takers had in making clear the experience that they had. Of those respondents, nearly all of those respondents reported having at least one technological issue. And the survey went into sort of details asking about very specific kinds of technological issues. Nearly all, as I said, of those respondents indicated having at least one issue, and many respondents indicated having multiple issues. We will be delving more into that survey data, but I just wanted to give you that top line information. We are also going to be doing an in-depth review of more detailed data, some that we have now, some that we are still requesting, to understand the experience of applicants. And we are going to be overlaying all of the data that we have with the reports of technological issues that were faced individually and by site. As I indicated, for example, there were issues, delays in starting the exam on day 2 for some of the test centers. So having that kind of detail will be helpful to get a better understanding of how the technological issues impacted test takers. Next slide. So we have, as you've heard today, and as I'm sure you've read about, received a lot of suggestions from test takers, from law school deans, and from other stakeholders about what types of things might be done to provide redress for the experiences that applicants had encountered. There were suggestions for individualized solutions, for global solutions, for solutions to specific exam components. I think one of the things that you've probably heard today is there does not appear to be unanimity of opinion on any of these solutions, right? There are some, and we'll get into these in just a minute, but there are some who are recommending, for example, provisional licensure, and others who are saying that's not a solution for me. There are a variety of solutions that are being suggested that do not work for all test takers. Next slide, please. Over the next 2 slides, I'm going to sort of highlight just a couple or a few of the, not a couple, a few of the remediation measures that we've heard applicants requesting. Individual point adjustments, Consideration of the experience that test takers had by the graders when they are actually scoring the exams, scoring the written components. We've heard suggestions to add a set amount of points to every test taker score. There have been suggestions on retakes for all or retakes for some. Suggestion to retake all of the, to allow everybody to retake the performance exam. Next slide. Suggestions to reduce the pass line or the cut score, or ensure a set percentage of test takers pass and sort of score, sort of set the percentage first and then score up to that point. We have heard requests for reciprocity for admission of attorneys who are licensed in other jurisdictions who had sat for this exam and were not able to demonstrate their competence. We've heard requests for refunds for all test takers or extension of the free retake opportunity that was extended to those who withdrew from the February 25 exam or who were not successful for the February 2025 exam. We have offered that for the July 2025 exam. There have been requests to extend that through the February 2026 exam. There have been discussions about the need for provisional licensure, the launch of a portfolio bar exam, or diploma privilege, or some sort of admission of all of the test takers, regardless of the outcome of the February exam. Next slide. So I want to talk a little bit here about some of the suggested remediation options, and then we will be proceeding back to Dr. Buckendahl to talk a little bit about the types of things that have been done in the past, whether at the state bar or in response to other disruptions or technological issues in high stakes exams. And to get a sense, we're not sort of saying this exam is exactly like what happened in July 2021, but we wanted to sort of present these suggestions or have these discussions as a way of sharing the types of things that could be available depending on what the data show, what the committee ultimately decides to do. Thank you. So obviously, as you all know, we have offered a retake to 87 test takers. The retake is scheduled for next week, Tuesday and Wednesday for most test takers, extending through Friday for any test takers who have an extended time accommodation. The full or partial retests were offered for test takers who are unable to launch the exam entirely, test takers who submitted fewer than 4 of 6 written components with fewer than 4 of 6 where there was content in the answer or the notes, because we were looking for both the answer and the notes, because we can and do intend to import the what's in the notes into the answer block, because we know some test takers were unable to cut and paste their notes into the question block, and so we'll be importing that as part of the grading. But also test takers who submitted fewer than 3 out of the 4 multiple choice question sections were also offered the retake. One of the other things that we did was look at the people who did have content on the 6 written components, the sample size, the sample of the people who had content on 6 of 6 written components, and then we looked specifically at the 50 or so individuals who had written content on 4 or 5 of the 6 written components, because what we wanted to see was the content sufficient to be graded? Some people, for instance, may have had content that was just a cut and paste from the question stem into their answer block, but then due to technological issues, we're not able to proceed beyond that. We identified several individuals who were in that, who had that circumstance, such that in essence, they really did not have 4 of 6 written components, and we added them to the retake as well.
It was a non-answer.
Exactly. The retake, as I said, is happening next week. For people who are remote, it will be on the Measure Learning platform. We had a week ago, Measure Learning had indicated to us that they could not offer the exam both in person and remote on the March 18 and 19 dates that had previously been identified and advertised. And we didn't think that was acceptable. And so as a result, we switched all of the in-person test takers to the State Bar's LA and San Francisco facilities. And we are providing that in-person exam not on the Measure Learning platform, but with hard copy materials for those test takers. We did therefore offer everybody who had already signed up to do that, the retake remote. In light of how we were offering the in-person exam, we wanted to give them the opportunity to switch should they choose to, and have the ability to. And we also, because there are only 2 locations now, San Francisco and Los Angeles, are offering travel reimbursement along the same policy that you all committee members use, submitting travel reimbursement when you travel to in-person meetings. And so that's what we've done on the retake front. On the other remediation measures, Devin, if you could advance the slide. There are a number of the measures that were suggested by applicants, and we just wanted to sort of make sure that that we were clear that there are certain things that the committee does not have the power to do alone. The committee itself cannot change the pass line of the cut score or ensure a set percentage of test takers pass. They can't pass all the test takers or direct a provisional licensure program or diploma privilege, or create a portfolio bar exam. Several of these things are things that the State Bar has advanced to the Supreme Court in the past, and the Supreme Court has rejected, including the portfolio bar exam. There was a recommendation to extend the provisional licensure program and use the remaining provisional licensees as a pilot for the portfolio bar exam. That was not approved by the Supreme Court. Several of these other items are things that the Supreme Court has talked about before. Obviously, the committee can make whatever recommendation the committee deems appropriate. We just wanted to make it clear that these are things that the committee itself does not have the power to act on. Next slide, please. There are also, and this is where I'm about to turn back to Chad in just a moment, there are psychometric solutions that can be applied. Chad can speak obviously a lot more intelligently than I can about what these are. We are sort of doing the first bullet, which is the retest for those who don't have sufficient content that would make it possible to impute scores. And that's how we selected what we did in terms of written content on 4 out of 6 written components, or not having the ability to answer more than one of the 4 multiple choice sections. Psychometrically, you can impute scores for the 5th and the 6th missing written component if you have scores for 2/3 of the component. Same for the multiple choice, and the multiple choice, the way that would break out is if you miss more than one section. Technically, that's 75%. I know, Paul, you would correct me if I didn't say that, but that was the easiest way to apply that rule to make sure that people had at least 2/3. And so we went for 3/4 of the multiple choice questions, so you could impute. There have been suggestions about having the circumstances that the test takers underwent considered by the graders as they are assessing the quality and the score for the exam. Chad will talk a little bit about sort of the importance of applying psychometric analysis and having the graders continue to grade the way they've always graded, but using the psychometric measures after the scoring in order to determine what adjustments might be appropriate. So ultimately what that sort of comes to is that as unpopular as I know this suggestion is, psychometrically, the best approach is that the psychometric analysis would follow the scoring of the exam. That the grading would happen, and then the consideration of looking at the psychometrically, look at the grades, they look at the issues to the best of their ability, and then apply the solutions, as opposed to deciding today or making a recommendation today to the Supreme Court that all of the scores should be adjusted in certain fashion, but rather having the psychometric analysis happen first. Next slide, and this is my last slide. There are some challenges that the committee members should think about too, with some of the global solutions that are recommended. One is sort of the inability to know for certain the extent to which all applicants were impacted by the technological issues. Also, something that the committee does need to have as part of their consideration, that the February bar exam typically has a low pass rate. It is for the last 10 years, the average pass rate in the February bar exam was roughly in the 35% range. And one of the reasons for that is that there are a higher percentage of repeat takers at a February bar exam, and this exam was no different. The percentage of repeat takers for February 2025 was in line with the percentage of repeat takers for our past February exams. And so the committee may want to consider whether certain solutions are appropriate or not as a result of sort of in consideration of that information. With that, I'm happy to take questions, or we can have Chad talk a little bit more about psychometric solutions and the extent to which they can address disruptions like those that were experienced.
Can I ask two quick ones?
Yeah, let's go with questions first. Go ahead, Paul.
Okay, so can you get this slide deck up on attached to the agenda?
It is.
Oh, it is as of today?
It was as of yesterday or the day before, but yes, it was up very late, and I apologize for that.
Okay, yeah, and I didn't get the normal, well, the hope for there's new stuff up there message, so I didn't look. Okay, secondly, historically, do some people often fail to answer all of the multiple choice questions?
I can only speculate as to that, and I don't want to do that.
Okay. Because the national conference graded them, so we don't know as much about the historical performance as about this one. Okay, thank you.
Other questions before we go to Chad, and then just to sort of set your expectations, after Chad talks about the extent to which psychometric solutions can address these kinds of disruptions, Audrey is going to engage you all in a discussion of whether or not there is an ability to expedite the grading for the exam.
And just in terms of timing, and I'll get to the questions in a second, it's 1:25. I know we said we'd break for lunch at 1. I would really like to push through these two, 4.1, 4.2. Is it realistic to think, Audrey, that we can get done by 2 o'clock maybe?
Yeah, let's try. That would be fine.
All right, let's push through. Justice Messawala.
I just have a very short comment, and I just want to thank Donna for this portion of the open session. I saw these slides as transparent, open, and honest, and that is the bar I would like to set. And so I very much thank you for this presentation, Donna.
Thank you.
And Judge Reyna, did I see a hand up before?
I did. I just also wanted to echo and thank you for the great presentation. But I think Chad might be following up on my second question, which was, I think is it like 9 weeks for when the results of the test would come back? I guess I'll leave it to him to determine for us to vote on remedies, right? How long is that going to take?
I'm going to talk about grading, but sorry. In terms of remedies related to grading, we can talk about that.
Yeah, let's have Chad go forward, and then we can talk about all of that. Chad?
Sure. Thanks, Alan. Okay, so just then kind of picking up where Donna was describing, so what sort of guidance is there as to how to respond to disruptions in administration? Technology disruptions have happened in other examination programs, and so this is something that there's a couple sort of industry documents that are used to provide some input on this. One being the professional testing standards, the standards for educational and psychological testing, in which the goal ultimately is validity, reliability, and fairness of scores and decisions. And so how we go about doing that, I'll talk a little bit about some strategies that the state bar has used previously, as well as other programs have used. There is also a document called the Technology-Based Assessment Guidelines, and specifically there are guidelines related to test disruptions, and then also responding to incomplete data. So Donna kind of mentioned the use of, for example, imputation as a strategy to estimate missing scores. That's if you have incomplete data and don't want a test taker to have to retake the entire exam, how much information do you need in order to get a reasonable estimate? And so we talked about this previously in that sort of 2/3 set of information in order to then estimate what a total score on a section would look like, was something that was driven in part by some of these imputation approaches. In terms of how to respond to test disruptions, some of the historical practice that has been used within California bars programs from the July 2021 examination, there were pro rata grading adjustments in which a baseline expectation was determined from unaffected responses. And this is an important point in making any sort of adjustment, you have to have some sense of, well, what would it have looked like had you not had disruptions? And so part of the investigation that is sort of that is ongoing in terms of the data collection is to what extent do we have a reasonable representative sample that we can establish some sort of baseline on? Because then to start thinking about adjustments from that, we need to know against what we're comparing. In that particular example, affected responses were adjusted upward based on that estimated performance. And so they looked at the baseline relative to the affected and then made a prediction as to what the score likely would have been in that instance. In doing those types of adjustments, you are making an assumption that there was nothing systematic about the applicants that were being affected. And so you're making the assumption that if the effect was sort of at random, then making these sorts of adjustments is simply providing some measure of linking or equating to balance out that sort of effect that occurred for those test takers. Regression is another approach in which using multiple sources of information. This is applied more to extensive disruptions, where in this case you have 3 or more affected written sessions or 2 or more affected multiple choice sessions. In this case, we are leveraging the predictive relationship between parts of a section of the exam, so parts of the multiple choice, relative to the total score on the multiple choice, or parts of the written component to the total score on the written component. In those instances, predicted performance was estimated for, again, the missing applicant data based on estimating those relationships among sessions and sections of the test. So again, you're relying on the that sort of predictive relationship that if you do well on a part, how well will you do on the whole. This is also in part why having the scores themselves be reliable is important, because if there's low reliability in the scores, we wouldn't have as much confidence then being able to predict a total score from a partial score if the relationship among those questions was not strong. In terms of some of the options that sort of psychometric options that would be available for the February 2025 bar exam, differential pro rata grading adjustments. So again, using that example from the 2021 exam, in which an unaffected baseline was used as a point of comparison. So you have to start again with that baseline, and then there is opportunity for differential adjustment based on the type and severity of the disruption. In doing so, what you are doing in those instances is looking at what type of disruption occurred, because, for example, a disruption where somebody was delayed 15, 30 minutes, as example, from starting their exam and didn't have further instances of disruption, had a very different experience from somebody who maybe had multiple disruptions or much lengthier sorts of delays in terms of their opportunity to demonstrate. This is why that data collected that Donna was talking about is so important, to be able to go to the evidence to say what types and how severe were these disruptions in order to have applicants identified within different sorts of groups, from like less severe to more severe. That particular approach then allows you to look at scores and say, okay, if I were to look at those groups separately, and going back to my item difficulty example, if I were to be able to disaggregate and say somebody who was in a category of less severe, what was their average difficulty on a question versus a group that had a more severe disruption. If we see no difference between those, then we can assume that the disruption didn't affect their ability to perform. If we did see a disruption, if we did see an effect of the disruption, we're going to see a difference. And presumably that the disruption would have suppressed their ability to demonstrate to come to their highest ability. And so we need that sort of baseline information from an unaffected sample in order to say, well, what would we have expected? What did we actually observe? So that's one type. Obviously, the imputation method, if you have missing data and you don't want people to have to completely retake the examination, looking at that, again, that predicted performance, using the multiple pieces of information. And for the multiple choice portion, those multiple pieces of information are going to be the questions they did respond to. And so again, taking the sort of relationship from part to whole, we can make a prediction as to what their score would look like for the total section of multiple choice or the total section of written, based on using the predictive relationship from individuals who were in sort of that baseline condition where information was information on their full multiple choice experience and full written portion experience as well. One of the other strategies is to use something called a makeup score replacement. And this is a makeup opportunity to say, if individuals weren't able to take the written portion of the test, could they retake just the written portion of the test? So for test disruptions in other situations, there are often instances where the frequency of administration allows for somebody to retake an examination more frequently. And so oftentimes the remedy is simply to retake the exam. For the February 2025 bar exam, we know that the next sort of full retake opportunity isn't until July, which is why the sort of makeup opportunity that's being offered, I think, next week is an attempt to try to get that additional information just to like complete the record in order to get that information for the applicants. As Audrey mentioned a moment ago, as it relates to the written section, from a consistency of your scoring rubrics or your grading criteria for the essay and PT questions, it is important to maintain the meaning of the scoring rubric for all applicants. Because if you have differential rubrics that are used for different applicants, you may actually be accumulating the potential effect of a disruption. And so from, again, purely from a psychometric perspective, the goal is to identify that baseline group, apply your normal grading practices, and then once your investigation determines the type and severity of the disruption that an individual applicant had, you then know, well, what would the expected performance have been had it not been for that type of disruption. And we can use the group level sort of information from others who had the similar type and severity of disruption in order to make that sort of estimate. But by modifying your grading criteria, it becomes it adds a confound into the interpretation of the scores, because is somebody then getting that score because you're using a different criteria for them that is modified based on the condition, and again, without knowing yet how many different sort of clusters of type and level of severity of disruption that occurred, you could have several different rubrics that you then may want to apply to the grading process, which because those essays and PT questions are human graded, actually adds more variability to the process and makes it more difficult to then interpret. So those are the primary, the sort of disruption opportunities, how you would respond to the disruptions in terms of different options. With the combination of, I think, all three of these potentially being something that the committee could be considering in their deliberations.
Ashley?
2 questions just on that last slide before we get into those discussions. How do we know who experienced what severity of disruption to apply that first option?
Well, and this is where I would go back to some of the information that Donna shared. And so knowing start and stop time. So for example, I'm just making this up, but if you were to see that somebody initially logged in at 8 o'clock in the morning, didn't finish until 10 o'clock at night, and had several different proctors assigned to them, right? So you can start to look to see what was the type of disruption? Was it, multiple login attempts, multiple proctors, those types of things, and also how severe was it? So as I said, one restart where you had a 15 or 30-minute delay is not as severe as somebody who was, perhaps taking the exam for most of a day.
And how do these models apply to test takers who have accommodations where their timing might be different, their experience might be different? Are they still viable?
They are. The sample size for the accommodated test takers has to come into play there. But we would also very similarly want to say if and how they experience disruptions, how did that potentially have a positive or negative effect. Actually, it wouldn't have a positive effect. What sort of negative effect would it have if it's directional in this case? One of the examples of this sort of approach, so a few years ago, there was a kind of a nationwide test disruption, technology disruption that occurred for the Canadian CPA exam, in which there were the disruptions were clustered in different regions of the country, and the disruptions were not the same. And so their board had to basically look at each one of those as almost a case to say, okay, the Toronto site had these types of disruptions. What did that look like? The Ottawa site, the Edmonton site, the Winnipeg site. So each one of those had like slightly different different types and different levels of severity. And so each one was kind of treated as a case relative to a baseline to then try to establish what type of adjustment may be necessary to ensure equitable interpretation of the score and ultimately a pass-fail decision for those candidates in that case.
Judge Reyna?
Yeah, I'm sorry. This is all very useful, interesting information. Thank you. I'm sorry. I just need to inform that I need to step away for another obligation, but I'll be back. But I was told I need to announce that. So thank you.
Thank you, Judge. Chad, on that last point, it occurs to me that over the years, there have been disruptions at various test sites for the California bar exam. And is this analogous to that, what you were talking about with different levels of disruptions and then different remedies for various test takers who were affected?
Yes, sir. And so in those instances, and that's where, again, the investigation and data collection to identify what were those disruptions and which disruptions which disruptions can basically be grouped together as similar. And the example that I just gave from from Canada, they had somewhat of an easier time only because they had sort of these clustered disruptions in different cities. For California, because you had a number of remote test takers, identifying what types of disruptions occurred for the individuals. And if it was at a site, you may have multiple people then within that site who experience the same disruption. And they would then kind of be, grouped together as these individuals experience this sort of disruption. And the challenge here is anytime you're doing grouping information like that, it is extremely difficult, maybe impossible, to estimate the effect that it has on any one individual, because the data are coarse in that regard, and the information that you'll have will be based on basically an aggregation of individual experiences that then connect to a particular group as you define what sort of disruption occurred and essentially how bad it was.
San Francisco?
Yeah. So I think so am I correct? Maybe this is for Donna. So we are gathering the technical data. So if we choose to, we can look and see how, from the logs in effect, of measure learning, how disrupted some particular individual was.
Yes, so we are collecting the logs of people who elevated issues to technicians during the exam. There's a sort of host of data that we have asked for that will help us in identifying these technological issues.
Okay, so we won't necessarily know if somebody, for instance, I visited the Roseville site, and while I was there, people were raising their hands, and the technicians who I'll say appeared to be pretty on the ball. The IT guys they had there that Measure had hired from some other consulting company. So would we be able to know about those particular issues if they didn't rise to Measure's attention? Sounds like we may not get all the data, but we'll have as much as we can get?
Well, there should be incident reports that were taken down in those kinds of instances. So we will also be overlaying everything that we have with the information from all of the incident reports. The ones that are, if somebody's remote, the incident reports are sort of, we get those sort of on a rolling live basis. For anything at the test centers, those need to be aggregated and sent back to us. And so we haven't had the opportunity to look through those, but that is an additional piece of data that we will be looking at, are those incident reports.
Okay, and then is any consideration being given to, first of all, whether there really would be measurable or significant effects, and whether we should gather data and attempt to, if we're going to consider compensating for stressors, all of the things that happened before the test started. Some people getting their appointments canceled, having to spend a lot of time on the phone to figure out where they were going to be tested, that sort of thing. Or is that too ephemeral to be a consideration?
I think that's a question for you, Chad.
It is a good question. Again, from a measurement standpoint, it's difficult to establish sort of a baseline state for an individual going into a high stakes exam. And what we have are obviously the responses that we're getting from the multiple choice questions, and in combination with the sort of experience reports, the surveys, and those sorts of contextual factors that influence. And so, how is it being factored in? I think it's being factored in indirectly through, if we are able to establish that there is a reasonable sample of what we might call unaffected, again, an unaffected examinee for the sake of baseline, that in then looking at the sort of differences between some of the different groupings of applicants that are, again, grouped by the type and severity of disruption, that gives us a sense of what the potential effect is between those groups. In terms of some of the purely psychological sorts of impact associated with that, it is not something that we have baseline information on, and it is not something that beyond the sort of self-report information from surveys, the testimonials, the sort of feedback from applicants that goes into it. And so how to quantify that is less of a psychometric issue, and it's probably more of a policy deliberation.
Okay, so I just hope the investigation that's going on will be looking into those issues as well, because I think we have some things to learn from that experience. Thank you.
Alan.
Vince.
Yeah, I just wanted to add on to that conversation, because one of the applicants needed an accommodation, and it wasn't clear where that person was going to take the test. And so I think, again, kind of what you're saying, Chad, it's hard to measure exactly what kind of psychological pressure that could have, or stress that could have put on somebody. But as long as somewhere it's being addressed, whether it's the specific test itself or the policies that lead up to an individual to take the test, I think that's all part of this process. Thanks.
Anybody else? Audrey, did you want to take up the next portion?
I do. Devin's going to put the slides back up. I'm going to talk about grading the bar exam. You can go to the next slide. So at the March 5th meeting of the Board of Trustees, the board asked for the Committee of Bar Examiners to consider ways to expedite the timeline for grading for this February 2025 bar exam to provide resolution more quickly to the affected test takers. Next slide. I just want to kind of back it up and explain what the process is. So grading is scheduled to be completed 9 weeks from the exam, which is 7 weeks, I think, from this week on May 2nd, 2025. The process begins right after the exam ends, where graders assigned to different questions get the questions so they can write their own analysis and outlines. They also are beginning to do independent grading throughout this process, and then they meet 3 different times for what's called calibration. Other graders assigned in a panel of up to 14 graders per question to discuss and calibrate their scoring. And those calibration meetings are spaced 1 to 2 weeks apart. After all of that process, this is kind of the phase 1 concludes, then there is something called second read, where applicants within 40 points of the cut score 1390, they are given another read. Just to give you some color on second read, in the last 2 February exams, 11.6% of all the applicants went to a second read, and out of that pool, 12.7% moved from fail to pass. Next slide. So the grading timeline over time has been reduced. The Committee of Bar Examiners met and voted in April 2020 to reduce the grading timeline. So the grading period for the February bar exam used to be 11 weeks, and it is now 9 weeks. The recommendations at that meeting were to increase the numbers of graders per panel to up to 14 per question. That was a recommendation by our then psychometrician, Dr. Roger Bolus. We also, or the committee also voted to remove a phase of grading called resolution phase that added a week onto the grading timeline, where after second read, those within 10 points of the cut score were given a third resolution phase of reading, and that had a negligible percentage change from fail to pass. So that was voted for by the committee to be eliminated in favor of a faster grading timeline. Next slide. So there are some areas that I wanted to put in front of you in terms of how we could and what the challenges are with expediting grading at this point in time. So increasing the number of graders per question is an idea. Right now we have up to 14 graders as the committee decided in 2020. Adding graders at this stage, which is in the process of grading that's already started, could introduce delays in grading those essays and the performance test, because there'd be additional training. Well, there'd be the sourcing of the graders, there'd be the training of the graders, and then you'd have to insert them in a process that's already begun. Eliminating the second read could shave a week off the grading timeline, but that would negatively affect the applicants because, as I just said, a percentage of those applicants move from fail to pass in second read. Could it eliminate a calibration meeting? There are 3 calibration meetings, but that would remove one of the essential quality control measures we have in place. And then there could be inconsistencies in scoring affecting the fairness and reliability of the process. Something that is possible for future consideration is where artificial intelligence can be inserted into the grading process. That's something in a very early stage of exploration. AI perhaps could do one pass of grading and then the human graders could take over. That could be something efficient to reduce the 9-week time period for February to a shorter timeline. But there isn't an ability at this time to insert AI grading into the process. What we would recommend at a future date is to take archival questions that we've used in the past and do a trial run with those questions and with human graders, and then do some kind of comparison based on inserting AI grading into a process. But it's not ready to insert AI grading into the process at this time.
Not ready for prime time. All right. Questions or comments?
Yeah, I cannot imagine how, given all the complexities we have another set of retest, grade, calibration between those 2. we're first time using the multiple choice questions. We have to, yeah, anyway, yeah, just no way. I don't see how that can happen. I hope we don't have to delay it. And my question, Audrey, was, is the calibration session still on for next Saturday, the one that we could attend?
Calibration is this weekend, unless I'm wrong. First calibration.
First calibration, but the CBE is invited to the second calibration, and that's scheduled for next week, and that's correct. An email reminder is going to the CBE out today. Excuse me.
Amy's not feeling well, but yes, you can attend second calibration is what she's saying.
Okay, so yeah, I think this one is, I don't normally go to them, but this one is going to be interesting, I think.
Any other questions or comments?
I think you can take the slides down too, Devin.
Okay. At this point, is it time to discuss 4.1 and the motion? Audrey?
Yes, so we did draft a resolution that was in the item that we can put up for discussion.
Let's put it up and discuss it. I have some thoughts, so let's put it up.
Audrey, do you want me to pull up the resolution?
Yes.
Sure, I think,
okay.
I don't know if Paul has his hand raised again.
Oh.
Yeah, I really prefer that the full committee have an opportunity to decide this. You know, this is.
I agree, Paul. I just want to put the motion up there so people
Okay.
can see this.
I think my comments can, to save a little time, I can.
Okay.
But if we were going to delegate to the chair and vice chair, I think we should add to the motion a statement of the principles you should be applying. Even if it's something simple as you know, wheeling out the bar's kryptonite, public protection. At least that's what I call it. You know, and saying that we want to be mindful of public protection, fairness to applicants. But to me, I don't think we can. We just can't give everybody a bar pass, especially in the light of the historic passing rate on the February bar. I would be open to asking the court to you know, create a new version or a correlate to the blanket on the term,
The portfolio bar exam?
No, not the portfolio bar exam, not that, the provisional licensure. But with the caveat, as the original program had, that at some point you have to pass the bar or the program ends and you are no longer able to practice. I don't favor, you know, trying to bring the portfolio bar exam via the back door, the side door, whatever you want to call it, as some propose. Those are my thoughts.
All right, well, let's put the motion up there, and I think maybe we can add to it and add Paul's thoughts.
Again, that's not my preference, though.
No, well, I just want people to be able to see it.
And Mr. Chair, I also, I have crafted sort of an alternative, if you wanted to consider something that specifically talks about a special meeting of the committee as opposed to, or as opposed to the chair and vice chair. I guess I can email it to Devin and she can pop it there on the screen.
Yes.
And I did it in track changes, so you can see that.
Yeah, can we make that a little larger?
Is that better?
2 more? 1 more? There we go, okay. All right, this is, This is without the changes, right, Donna?
Right, I just emailed Devin a different version.
Okay.
That will show some changes in.
Okay.
track
Yeah,
changes.
I just want to comment. I do think this is so important that we should take every effort to have the full committee weigh in on this. And to the extent that we need to call a special meeting, I think we should do that. Does anybody else have comments?
Is the next meeting scheduled a month from now?
Oh, I can do it on the top.
We may need a special one before that.
So this is Michael. I would second our chair's motion to have a substitute motion.
Okay. Well, let's see what Donna has.
Okay, I realized I could add it, so I just added it. But
Okay.
it did not show up because the whole document's in track changes. So it didn't show up as track changes, but it does a couple of things. So let me just walk you through what it does. One is making clear that a scoring adjustment is a recommendation from this committee to the Supreme Court and not sort of a final decision. Two, it says, changes the language to say if the timing of when a scoring adjustment is needed doesn't align with the regularly scheduled meeting, and a special meeting of the committee cannot be timely scheduled. That would sort of really only be in the instance where we can't get a quorum of the committee in the time that we need it, and that can be spelled out a little bit more if you would like. Then the authority to make a recommendation on the scoring adjustments would be to the chair and vice chair. We can just take that out and just say a special meeting shall be called, period, and not have a reference to the chair and the vice chair doing it. And then I added on the bottom that the making clear that the recommendation will be submitted to the Supreme Court for approval. And I was just trying to toy with Mr. Kramer's suggestion of any scoring adjustment recommendation shall take into consideration public protection.
The danger of just saying that it has to be with the special meeting is if we can't get a quorum.
Right.
So I think we should have the fallback. Ashley?
Yeah, I don't know if we're talking about what remedies we think should be included because this only mentions the scoring adjustment, but I think it doesn't look like we can reasonably and without risk speed up the grading process. And I still think that the February bar takers need a remedy that's going to address as many of their concerns as possible. And to me, that seems like a combination of the provisional licensure, the psychometric adjustments, and maybe even an adjustment to the pass score. So I'd hate to send this up with just mentioning the scoring adjustments if more of us are in favor of a different alternative. And I think we've had positive feedback from the participants in the 2020 provisional licensure program, both supervisors and licensees. We have the infrastructure ready, and I think I also actually I'm probably a little bit more aggressive about this than some of the other bar members, but I think this should also extend to the people that withdrew as well. I think that they're also still impacted and they made a decision, and I don't think that they should be excluded from any remedies. And I'm not worried about the higher level of retakers on a February bar. If people are truly not competent to practice, I think that the provisional licensure program has been good in determining and finding that out just as well as the bar, and probably even more accurately. So that's what I would ask, is that if we do push something up to the Supreme Court, that it include that provisional licensure.
But are we clear what provisional licensure is? Because I think a lot of people,
That's a good point.
you know, it still required passing of a bar exam or retroactively passing it because they retroactively applied the lower now current cut score.
And I agree with that I think that the people on the provisional licensure should be held to the same standards as the 2020 ones, which is that they are expected to eventually pass a bar, whatever that might look like. If they don't meet the standards that we've placed if there's any that come out of the scoring adjustment or any kind of pass score cut. I think that still is reasonable. I think it just makes sense. I think this is another extenuating circumstance that occurred in 2020. And I took the 2021 bar, so I took it remotely. And I think that it was still, and it sounds like from all of the public comment, that it was still an entirely different experience to what I experienced, and not in a positive way. And so I think that's what we are trying to maybe not
No, I agree.
figure out, but remedy maybe.
I agree with you. This is people that tried to take the bar exam and it failed for them. And back in 2020, it was people who were afraid of getting COVID from the person sitting 6 feet away from them. It's similar enough to me that, yeah. So what we could do, Ashley, is add a second resolve to this, that we immediately recommend to the Supreme Court that they expand the provisional licensure program to include, and I'm happy to give that to people who withdrew from the exam, because what was going on right before it probably, reasonably gave them great pause.
Okay, so Donna, you're going to add that in? Let's.
Right now.
Okay, are there any other comments on that point?
Should we make that a recommendation, though? That's just ordering them sounds a little presumptuous.
Yes.
Yeah.
But Vice Chair?
Yes.
I just want to provide my support to that.
Okay.
approach.
Is there anybody else who has any comments? Yeah, just on that point. I think we're all, it sounds like we're having consensus here. Leah, you,
Yeah, hi. Thanks. I've been listening in so far. I just want to clarify, this is a recommendation that the committee would recommend this now or after grading for those who didn't pass and those who withdrew, or just recommend it now for everyone before we have even scored the exam.
Well, it'll take the court a while to get around to this. So I think we want to get them started.
I agree. And I think, obviously it wouldn't override if someone passes, then they wouldn't need the provisional licensure. We'd be fine anyway. So I think, I don't exactly remember how long it took them in 2020 to approve. But I do recall it was some time.
Well, yeah, it took a while because I was a member of a working group that met for a couple months to write the court rule and I think the bar rules. So it wasn't in. Now we at least can plagiarize, but it's still, they don't meet that often to deal with these things.
and we can't speak for the court, but once it's on their table, they may want to wait to see what happens. But I agree. I think we should get it moving now.
So if you drafted this too narrowly, then what I hear you saying is you want to recommend that the court expand the provisional licensure program to include anybody who took the February 2025 bar exam or who withdrew. Not, I wrote it as people who were unsuccessful, because what I hear you saying is, if possible, you'd like this to be implemented before May. So before we know if they were unsuccessful. That's what I heard in the discussion just now.
Is that what you were intending, Ashley?
I'm thinking about it.
I-
Yeah, if you have an
The
opinion,
remedy-
I don't know if I feel strongly.
I mean, the withdrawers, they have no reason to wait because they're not going to get a
True.
pass. So letting them go sooner, I don't see a problem with that.
I think as soon as the Supreme Court makes a decision, why not?
And if somebody, is waiting if they're going to get their results in a week, they're probably not going to bother with this until after their results come out.
So I changed it to test takers who took the February 2025 bar exam or who withdrew.
Yes, please.
Okay, that's how it now reads.
Okay.
And I'm sorry if I can just ask maybe our general counsel staff to opine. We've had a lot of discussions about I think fair to say, confusion about CBE versus the board on some of these issues. In the past, I believe the provisional licensure program recommendations, or at least the extension recommendations came from the board to the Supreme Court. I may be incorrect, but anyone from OGC want to opine if this can go straight from CBE to the court in your view?
You know, Leah, I was just trying to pull up whether the extensions went to the board. My understanding is that the initial program, there was a working group that went to the Supreme Court. So I'm trying to pull that up. While I do, Donna, on the first resolved, can you please remove special meeting? Because that has some significance legally, but we don't need the word special there. So if you could pull that out, I would appreciate it while I track this down.
Let me give you the history on the provisional licensure proposals, what went where. So the initial provisional licensure proposal was developed by a working group that was named by the Board of Trustees and had as its chair a representative of the Board of Trustees. It included 2 representatives of the Committee of Bar Examiners. The proposal went from the working group to the board and then from the board to the Supreme Court. The extensions of the provisional licensure program went to the board and from the board to the Supreme Court.
Yeah, kind of on an emergency basis, so that's why we weren't consulted. So does that doesn't definitively answer the question about whether it has to go through the board this time. For that matter.
When is the board's next meeting? It's not until May, is that?
Okay.
It meets in May, but they can also come together either as a full board or through the executive committee sooner if necessary.
For that matter, when we decide about any remedies, is that going to have to filter through the board?
So to the extent
I'm on a call. The discussions that, and Alan or Donna, correct me if I'm wrong, but the chair and vice chair of CBE, myself, the board leadership, we did have the opportunity to speak to the bar's Supreme Court liaison. My understanding is the expectation is scoring adjustment recommendations can come directly from CBE to the court, but that may be distinct from provisional licensure because again, of that history. That's why I asked the question. But it's not our understanding that the scoring adjustment recommendations need to go up through the board.
And as Donna noted, the prior petitions did go through the board, and to the extent that this is going to require any rule changes, that may also be required to go through the board. So it could be altered to say that the Committee of Bar Examiners recommends to the Board of Trustees. We could phrase it that way.
Can we split the two? Provisional licensure, separate that off because that would have to go to the board, but the remedies would not?
I think if you just describe the different paths and the 2 resolves.
Right.
So what about rule changes then, Leah? Do we need to, I mean, I'd be glad to help with that. I wrote most of the originals, so, but would that have to come back to the CBE?
If the committee is making a recommendation to recommend to the board that the provisional licensure program should be extended and expanded in this way, I think, Paul, what's likely to happen is that the board would weigh in on that and transmit it to the Supreme Court. Whether that would include any proposed rule changes, including rule changes in the rules of court, I think is not something that necessarily needs to be, who's doing that doesn't necessarily need to be decided today, but I think that may be part of the process.
Yeah, I'm just concerned or thinking that it's going to delay the start date for these folks. I'm trying to, do the best we can to make it come sooner than later.
Well, if we feel it's necessary, why don't we, on the further resolved, that the Committee of Bar Examiners recommends to the Board of Trustees to recommend to the Supreme Court to expand the provisional licensure program.
And I just want to note as well, and we'd have to evaluate this, but to the extent rule changes are required, generally public comment is required. So I recognize there is a desire to move this quickly, but there are some constraints there that we can continue to evaluate.
Of course, the court maybe, if they order something, they can maybe short circuit some of that too, if necessary. But okay, we'll do the best we can.
I also heard the committee say the words sort of, I think I heard you talking about, sort of, what about other potential remedies? And so I also have a resolve that reads a lot like the first one, but that is broader. So the first one is just about scoring adjustments. The second one, I've got one that I can put up here, which basically says, and if there are other actions or other recommendations that you need to make, that would also be done, again, using the same language at a meeting. If a regular scheduled meeting can't be held, then it'd be, and if there's not a regular scheduled meeting and a meeting cannot be timely held, then the committee delegates authority, etc. If you wanted to also have something broader in case it was not just scoring adjustments and just today's recommendation about provisional licensure.
Well, speaking personally, this is as far as I want to go by way of remedies. So, but if somebody else wants to leave it open for other things, I guess I would be less willing to delegate to the chair and vice chair, cut score changes, that sort of thing. In the absence, I'd be willing to consider it at a subsequent meeting of the full committee. But maybe that's my little fine point on that. I don't know how others feel.
This is Alex. I mean, do we even need this motion? I mean, we haven't even scheduled a special meeting, and we really don't know whether we can have a forum. And I think I echo what Alan said earlier, that I absolutely prefer that the whole committee be involved in this process.
We should probably pick a date, just to
Well, let's one thing at a time. To the point that Paul just raised, I mean, I prefer to have it in an open, as many, leave it as flexible as possible. But that assumes that the full committee be weighing in. I don't know that Alex and I alone would be recommending cut scores, reductions, or things like that.
Right. Applicants can serve as many meetings as we need to make sure we provide the appropriate relief. And, if we don't meet until May, then we need to come up with and schedule another meeting in a week, 2 weeks, even next month, to ensure that we are well informed about one, but also understand the scope of the truth.
Well, this current formulation would still allow the full committee to make any of the other recommend any of the other remedies. It would just not let the chair and vice chair in our absence do it.
That's fine. I don't know if you want to build that into the motion. If you can do that, Donna.
So add the additional one? Yeah, certainly I can add that.
That's probably useful to telegraph to the, because we have a lot of people who are going to take a message about where we're going. It's unfortunate we can't provide a solution today, but as staff has has presented to us, we don't have the information yet, so we're not able to.
Yeah, I think staff's done a great job pulling together as much as we can in this short time, but we do need more time for this. So I think this is the best we can do today. Donna, are you typing there?
So I can read that. showing up there. So I added it as the second resolved. Resolved, I'm sorry. That if any issue relating to the February 2025 bar exam or March retest emerges, which requires action by the Committee of Bar Examiners, and the time in which that action must be made does not align with a regularly scheduled meeting of the committee, and a meeting of the committee cannot be timely scheduled, the committee delegates authority to the chair and vice chair to take action.
Still says special.
No, I took it out.
In the black part? Oh, so it's the, I'm sorry, I'm looking at the red one. You're right.
Any decision made pursuant to this delegation shall be reported to the full committee at its next regularly scheduled meeting. Any actions, that require approval by the Supreme Court shall be presented to the court for such approval.
I do see the word special meeting in the black portion.
Donna, it looks like the language is repeated twice, once in red line and once in black bold.
Okay.
So is it the red or the black that we should be looking at?
All right. All right. Is there any further discussion of the motion as is presently drafted?
No, that was the original.
I just want to, so just to be clear, the black bold is kind of just a repeat, and then the one above that is being replaced, right? Just so it's clear, because then we lost the public protection interest. Or is it all of it?
Donna's screen is different than what's projected. That's what's confusing me.
Oh,
Yeah.
okay. Okay.
Yeah,
Devin,
so
could you scroll up, please?
Is that good?
Whoever's screen. So I want to offer one suggestion, just because I think this is what is contemplated by the committee. For the first resolve, that if the timing for making a recommendation on any scoring adjustment for the February 2025 bar exam, to ensure that we're clear about the delegation. And then I think the black text on Devin's screen is a repeat of the paragraph directly above it. Is that correct? Yeah, so that should come out.
It's hard for us to see it down here. Can't see it at all now.
And then should that second one now be further resolved?
yes,
Good.
thank you. And the public protection tail was put on the first one. Any scoring adjustment recommended shall take into consideration public protection. Should that tail be added to the second one as well?
Our tech folks recommend zooming in so we can all see it. Zooming in 2 or 3 notches.
I've zoomed in. It's hard to capture the whole resolution. So I can just scroll up to the top if that's helpful. And then back down.
Was I adding that public protection tail to the second one?
Yeah, I think it's equally applicable to that.
So then it's any such recommendation or such action. Maybe it's actually.
Or. Yeah, okay, yeah.
Maybe it's actually shall be guided by the mission of public protection.
There's space missing.
Alan, Justice Macy Walla has her hand up.
Thank you. In the second paragraph that begins further resolved, I noticed that the word action is being used, which is fine. But then about midway down, it says any decision. Should that word decision be replaced with action?
Yes.
We're talking about the same action, right? So I think we need to be very consistent that it's not the action and the action is the same. It's not action, decision and action.
I apologize. That was, I had originally written decisions and realized some of these are recommendations to the Supreme Court. And so I changed it from decision to action and I missed that one.
Is it action? Aren't actions taken rather than made?
I'm not so concerned about that. I just think
You're looking for the consistency.
because each of these words have different meanings, right? An action and a decision can be construed differently in a paragraph that uses two different words. So I think we need to be very clear that we're using the same term throughout.
I've made that change.
Okay. And then all the way at the end, in the final sentence, I think you say, and it is.
Because there's one more below it.
The
Further resolved.
There's the
Scroll down, Devin.
One is below it.
provisional licenses there. Scroll up.
Shall be guided by the mission of public protection, and it is.
Further resolved about the provisional licensure program.
It's just the continuation to the next.
Oh, I see. I see. Okay. All right.
I'll make that motion.
I'll second.
All right. And is there any further discussion on this motion? Seeing none, Devin, can you take the roll call?
Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Kareem Gangora,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn,
Yes.
Justice Macy Walla,
Yes.
Bethany Peak,
Yes.
Ashley Silva Guzman,
Yes.
Judge Reyna, Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Alex Chan.
Recused.
With 12 yeses and 0 nos, the motion passes.
All right. It's 2:30. I know we said we go to 4.2, but I'm going to use prerogative. We're going to take a 15-minute break. Everybody stretch, do whatever. Please be back here promptly at 2:45. We still have a lot to do today. Thank you.
Is there a way to like get non-timely agenda items?
Can we mute the conference room, please?
Did we have a lunch period?
Are we back in session? Are we live?
We
Devin?
are. We are.
Thank you. Members of the public, thank you for bearing with us. It's been a long day, and some of the members this is their first chance to eat anything. this afternoon, so please excuse us. We're doing somewhat of a working lunch meeting here. At this point, let's go move on to 4.2. Audrey?
Thank you. Let me share my presentation. Devin, can you see this?
It's still loading. Oh, now we can.
Okay, whoops. All right, I'm just going to talk about the July bar exam. So the court had a brief statement about planning for a traditional in-person bar exam. So since that, we've been planning on the staff end for a traditional in-person bar exam for July. We have standard sites on hold in the greater Los Angeles area, Pasadena and Ontario, San Francisco area, which is the Oakland Convention Center, Sacramento area, the grounds at Roseville, and in San Diego, we are close to confirming a location. Hopefully we'll get that confirmed. We have sites for accommodated applicants on hold in Pasadena and Anaheim, in Oakland, and in the Sacramento area, but we're looking to secure additional smaller sites with private or semi-private room potential. I know the law schools have offered to help with that, and we will probably be calling law schools. We did use 2 law schools in July 2024. We also need to resecure a vendor for in-person testing. In prior administrations, that vendor was ExamSoft. We've, of course, reached out to them. Doing our due diligence, we're getting quotes from others, other vendors that other jurisdictions use just to do the due diligence, but we have reached out to ExamSoft. The only change that would be considered for the July exam in terms of the software would be whether or not to have the multiple choice questions answered in the software versus bubbling on the Scantron. Using Scantrons increases the potential for applicant error in terms of misalignment or tearing or ripping the Scantron. Scantron sheets can get misplaced, and in surveys, we have asked that question about whether or not someone would prefer to enter multiple choice questions in software. I think it's something like 64% said they would like to do that.
Can I ask about that?
You can.
Yeah, would they get the questions in a written form? Some of the comments have said they like to mark out the ones, you know, as they eliminate possibilities among the multiple choice answers, or would it all be on the computer? Because I do recall some comments that didn't seem to like that approach.
We could do it either way. We could have the questions loaded in the computer and a paper copy. We could have a paper copy and just the answers in the computer, or we could have just the questions in the computer and not a paper copy.
Okay. I mean, I can see the utility of the approach they were advocating.
Just a little on costs. We were forecasting costs in advance about what if we did a traditional July bar exam, and the forecast is between 4.8 and 5 million for a traditional bar exam across sites in California. That forecast was conducted before the potential increase in applicant numbers from February. So if we see those numbers of withdrawals and anyone who is going to get a waiver from the February exam, our applicant numbers could increase, which means our costs would increase. The bar exam application is not yet open. Of course, we want to open that application as soon as possible. So we're looking to open the week of March 24th. And then we have a resolution affirming the idea of going back to traditional in-person. I'm going to stop sharing if Devin, you want to share.
Yeah. So this is for 2.
Yes.
We've been ordered to do that. Do we need a resolution?
The order says to plan for. So in terms of making sure that the Committee of Bar Examiners agrees, we did draft this resolution.
So I had a couple questions.
Go ahead, Paul.
You know how in the past, I believe you would get the morning's worth of written questions, you get all three, and you could sort of allocate your time among them. You didn't have to finish one and then start another and be limited to 1 hour each. Are you going to go back to that old 3 at a time approach?
I think that would be covered in the traditional way we would administer the exam.
Okay. Let's see. I guess I just caution you, make sure, you really have proven performance from it. I think we've had a fairly good track record with Measure, except for 2021. They had some problems that we heard about at the scoring adjustments. But, I want to be really sure that if we got, whoever we get is going to be up to the challenge. I suppose it'll be a little bit less in that the laptops won't have to have a continuous connection with the server. Is that right?
Right. The way the ExamSoft platform works for in person is that they upload the answer files whenever they next connect to internet. So they don't need to have an internet connection during the exam.
Okay, so that'll solve one of the problems that plagued us in February. I do have some questions that relate to the questions and the security of the exam, so that we'll save those for the closed session.
Are there any other questions? Can I get a motion on this resolution?
I'll make that motion.
Is there a second?
Second.
Second, Alex Lawrence. Devin, or is there any further discussion? Hearing none. Devin?
Ashley has her hand
I was
raised.
like, have my hand
I'm
up.
sorry, Ashley.
The
Ashley.
remote difficulties. No worries. I think that I would be remiss if I kind of let us just go straight to a vote. I know we're kind of in a tight position here because it's what the Supreme Court wants, but I do think that we're overcorrecting and just saying, well, this was one unsuccessful attempt and now it's never going to work again. And part of what the staff's report mentioned is that while this might be financially viable now, it won't be for very long, and it hasn't been for very long. I think that there's ways that we can make remote testing work for test takers and not on such a rush timeline. And I really think and encourage that we take that up in future meetings and make it a longer term goal to do that. And I also think that if we're going to consider this return to in-person, maybe this is related, maybe not, but I do think that we need to start also talking about alternatives to the bar exam in its traditional sense. And one of the suggestions that I've heard thrown around by other test takers, and even when I was in law school, was releasing the exam topics in advance, which makes it more like attorney practice. Attorney practice is not something that happens in the dark. You don't just come into a case and have to know law. So I think that that's something that we can do that would make it more akin to practice and also potentially help us in the future. So I want to raise those points and kind of have that in consideration while we're making this vote.
I think those are great points. This last experience may have been a little bit of a setback, but I think we're still committed in the future to making the remote testing process viable. And I think that remains our long-term goal. And
we do have the project to create the new bar exam, so that's covered. But we could add further investigating remote testing to the work plan later.
Yeah. So I think going forward, this will remain a priority. And the other suggestions, there's a lot of other suggestions out there concerning the bar and the future of the exam. So we'll keep those on our docket for the future. So we had a motion and a second. Is there any further discussion? Seeing none, Devin, can you call the roll, please?
Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Kareem Gangora,
Yes.
Larry Kaplan, Larry Kaplan, Larry,
Yes.
Paul Kramer,
Yes.
Yes.
Alex Lawrence,
Yes.
Esther Lynn,
Yes.
Justice Macy Walla,
Yes.
Bethany Peak, Ashley Silva Guzman,
No.
Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Alex Chan. With 11 yeses and 1 no, the motion passes.
Thank you. We're going to go back to the beginning of the agenda now, director's report. Audrey,
I think it's chair's time, actually, at the beginning of the agenda.
chair's time. Well, Alex.
With the work plan and then the approval of the minutes would be right.
All right, that is correct. So with respect to the work plan, I'd like to suggest that we don't discuss that in detail today in the interest of time. If nobody objects, unless there's somebody who has something in particular they'd like to raise.
Well, I think we could just add Ashley's suggestion that we continue to investigate the possibility of remote exam administration.
Remote exam and the structure of the exam itself, which is, it's already been pointed out.
There's an item for that in there already.
Yeah, there's already an item. All right. Can we add that to the work plan, Audrey?
We can.
That'd be great. Thank you.
Yeah, okay. With respect to the minutes from the last meeting, can I get a motion to approve the minutes?
This is Michael, make the motion.
And I'll
there a-
second this is Justice Maciuala.
All right. So it's been moved and seconded. Does anybody have any discussion? Devin, please call the roll.
Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Kareem Gangora,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn,
Yes.
Justice Macy Walla,
Yes.
Bethany Peak,
Abstain.
Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes,
Abstain.
Alan Yokelson,
Yes.
Alex Chan. With 11 yeses and 0 nos, the motion passes.
Next item is the consent calendar. Unless anybody wants to pull a specific item off the consent calendar, we will vote on it as a group.
I'll make a motion.
I'll second that motion.
All right, Paul Reyes moves to accept and Michael Cow seconded. Any further discussion? Devin, can you call the roll, please?
Sure. Just to confirm, was it Vince Reyes that made the
Yes.
motion? Okay,
That's what
thank you.
Did I say Mike?
Interchangeable.
Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Kareem Gangora,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn,
Yes.
Justice Macy Walla,
Yes.
Bethany Peak,
Yes.
Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Alex Chan. With 13 yeses and 0 nos, the motion passes.
Thank you. Item 3.1, administrative updates regarding law schools. Is this Natalie? That was, I'm sorry.
Yes, I believe it is part of the consent agenda.
We're on 4.3, Lincoln Law School.
And it is. So 4.3, action on the application for accreditation.
Yes, Paul, would you like to make any sort of statement before I begin the presentation as you requested?
Oh, go ahead.
Okay, thank you. So just to remind the members and also the public comment for law school items is handled differently. After the staff presentation, the law school will have 5 minutes to have the administrator or administrators give public comment. So after my presentation, I understand that Dean Jason Amezcua is here. He may bring others along with him, and he will have the opportunity to decide whether to provide public comment. The action item here is the application for accreditation of Lincoln Law School of San Jose. This school is currently an unaccredited fixed facility law school. It has been in operation since 1919 in the community of San Jose. It operated as an accredited law school from 1993 through 2022. After that period, unfortunately, it was not able through that time to meet the minimum cumulative 5-year bar exam pass rate for the cycles 2020, 2021, 2022, 2023. In 2024, its calculation returned to the 40% or above required level. These levels are reported in July, and then in August, the school applied for accreditation. The committee reviewed the initial application in August and approved the school to move to the next step, which is an inspection to verify the materials in the application and verify the school's level of compliance with the rules for accredited law schools. So that's a 2-step process. The first is to make sure that the school has full compliance with the core rules. And then the second is to determine whether it has substantial compliance with the remaining, which would allow a provisional accreditation, or full compliance with the remaining, which would allow a full accreditation decision. Here, in the period between the time the law school was last accredited and now, a new set of rules has come into place. And so the law school has taken the steps not only to return to compliance in the area of the MPR, but to demonstrate compliance with staff and the team believe both the core rules and full compliance with the remaining rules. Therefore, a staff recommendation of full accreditation is proposed, and the next inspection should be set in 2 years. One issue of note that the committee discussed previously was that the law school expressed some financial concern back in the spring of 2024. This was discussed and shared with the committee. The school intended and made a projection that it would take care of this through a combination of enrollment increases and donations. While it did not meet its enrollment target, it was extremely successful in bringing about donations from the community. And consistent with that community support, the law school has received a number of very positive public comments from a range of community partners. So you're seeing not only support in spirit, but also support in financial commitment to help the school with any bridge. They have secured 3-year donations, 2 years remain on those. They believe that if the school is accredited, they will be able to continue those donations, perhaps receive more. And they also believe they will have a reasonable opportunity to greatly increase their accreditation, their enrollment for their first year class next year. They will remain in the fixed facility format. That is the choice of the school. They are extremely connected to their community, and they value having an in-person program located downtown in their community. So that's what I've prepared. I'm happy to answer any questions, but before we do, I'd like to recognize Dean Amezcua. For a period of up to 5 minutes of public comment.
Thank you. Can you hear me?
Yes.
Great.
Welcome, Dean Amezcua.
Thanks. So thank you, Chairman Chan, Vice Chair Yokelson, and committee members. I am Dean Amezcua of Lincoln Law School of San Jose. I'd like to first recognize and thank the inspection team, Dr. Bolton, for your thoughtfulness and wisdom, Mr. Kelly for being gracious and inquisitive, and Ms. Zielinski for your professionalism and being a great representation of the staff. I also want to thank and recognize the staff of the Office of Admissions. As we all have seen today, their hard work is ongoing, and they've been very communicative with us. The inspection process was, as always, thoughtful and engaging, and did result in a lot of positive outcomes for Lincoln Law School of San Jose. And while we're a small, independent, nonprofit institution, we are very proud of the role that Lincoln plays in Silicon Valley and in the Santa Clara County community. I hope that the State Bar will also recognize the effort that Lincoln and myself individually has made in being active and engaged with the State Bar staff and on committees. And Lincoln is also committed to partnering with and collaborating with the State Bar staff, California accredited schools, and the registered unaccredited schools to address any and all issues and finding sensible solutions. As Natalie pointed out, the committee has received letters from a small group of Lincoln stakeholders, and I want to thank publicly Assemblymember Ash Kalra, Senator Dave Cortese, the San Jose Chamber of Commerce, the Santa Clara County Legal Professionals Association, the Santa Clara County Bar Association, our building owners, and our faculty for their letters of support. I hope the committee will take the time to read those letters, as they are a true representation of the impact of what a California accredited and the registered schools can have and do have on supporting the legal profession. Finally, I want to recognize our students and alumni of Lincoln Law School of San Jose for their continued support, resilience, and their commitment to their legal education and careers. They are ultimately the most important constituency and the reason for all that we do. Thank you for your time, and I will cede the rest of my time for any additional questions.
Thank you, Dean Amezcua.
Are there any questions? Okay. Thank you very much, Dean. Thank you. Natalie, is there a resolution or motion to make? How do we do this?
Natalie, I think you're muted.
You're
So
muted,
sorry.
Natalie. There you go.
Yes, there is.
The recommendation of staff is to approve an accreditation. And Cody is sharing his screen. Thank you. So
Yes, so the recommendation is to approve, to make a finding that the school has demonstrated compliance with the core and remaining rules, and to set the next inspection in 2 years.
all right. Is there any discussion on this?
This is Michael. I'll make that motion.
I'll
second it.
I'm sorry, who seconded? Alex Lawrence seconded. Michael Cow made the motion. Any further discussion? Devin, please call the roll.
Dr. Bolton?
Yes.
Dr. Cow?
Yes.
Kareem Gangora?
Yes.
Larry Kaplan?
Yes.
Paul Kramer?
Yes.
Alex Lawrence?
Yes.
Esther Lynn?
Yes.
Justice Macy Walla?
Yes.
Bethany Peak?
Yes.
Ashley Silva Guzman?
Yes.
Judge Reyna?
Yes.
Vince Reyes?
Yes.
Alan Yokelson?
Yes.
Alex Chan? With 13 yeses and 0 nos, the motion passes.
Congratulations, Dean. All right, item 4.4. Natalie?
I believe this is a rules item. And Chair is getting ready to share her screen. We'll return to ed standards in the next.
Thank you. Terry, you can go ahead and go to the second slide. As in the interest of time, I am going to move rather quickly, cutting the length of my overview, just so the committee can go ahead and ask questions or raise any issues on the proposed rules. As a reminder, the PTLS program allows law students to receive practical experience while they're in school, and the law office study program is an alternate pathway to legal education. The specific proposed changes for the PTLS and the LOS rules are attachments B through G of the agenda item. The revised PTLS rules propose renaming the program the Certified Law Students Program to align with existing court rules, and it expands the program to allow law office students and LLM students to participate in the program. Additionally, clearer guidelines have been added regarding eligibility, particularly outlining when law students can apply for certification, when they must exit the program, and setting specific deadlines, such as notifying the state bar within 30 days, replacing the vague requirement of promptly. For the law office study program, the revisions modernize the program by incorporating technological advancements in adapting the changes in legal practice while providing more structured oversight. Notable changes include allowing a portion of the program to be completed remotely and clarify study outlines and reporting requirements, including those that center around the changing of supervisors. Clearer definitions of law study periods are included in the revisions, as well as reporting and attestation requirements from supervising attorneys or judges, and a framework for an academic progress evaluation. The CBE is now being asked to submit these updated rule revisions to the Board of Trustees for approval, and if accepted, the proposed changes will undergo a 60-day public comment period before any further action is taken. So at this point,
I can just add on really quickly, Christina.
Yep.
We just wanted to thank Paul again for your suggestions. I know we incorporated several of them, and we just wanted to call them out really quickly. So for the rule of court for PTLS, we actually added or have graduated in this D1A to ensure it was alignment with both the state bar rules and D2, 3, and 4. And let's see if hopefully it switched because I'm sharing the one screen. For the law office study rules under M, we did change the after to 4. And then I will tag David in here, but I did want to call out, I think for O in this part, this is the section where it's intended to allow those who are currently in the program at the time the rule changes, if they are approved, go into effect, continue to supervise those students. But if they have any new students, they would have to meet the current requirements. There was a small typo here in the citation, if that made a difference. But David, did you want to chime in on that one too?
Yeah. Thank you, Paul, for your comments. You were wondering with respect to this provision, what the difference was between the old rules and the new rules and why this was necessary. And the old rules required attorney supervisors to be admitted to the, quote, active practice of law and be in good standing for 5 years, which was not entirely clear. The new rules explicitly require them to not only be active, have an active license and be in good standing, but to have actually practiced for the 5 consecutive years immediately preceding the supervision. But given that clarification, it seemed like it would be unfair to stop supervision that's already taking place. And so that's why we included these.
Yeah, I have one more question, which was, why are we not requiring them to have at least filed a moral character application?
Sure. So the Practical Training of Law Students program, or now the Certified Law Students program, it's generally a way for 3Ls to be able to participate in law school clinics and get practical experience practicing law while they're still in law school. historically, they have not been required to submit and go through the entire moral character process before they even do that in their 3L year. And I just point out that, whereas, for example, provisionally licensed lawyers do have to go through moral character, they have to at least have an application submitted and they can't have gotten a negative determination. They have broader authority to act than do law students. Law students, for example, cannot make appearances or do certain other tasks without getting the written consent of the client, things like that. So that's the thought, that this is earlier in the process. They're law students. They're being supervised very stringently, and so they don't have to go through the moral character process.
But the supervisory requirements for government practicing students are less strict, right?
It allows them, I think, someone else in the organization to oversee them, but otherwise it's not so.
All right. Yeah, you moral character guys are always really hard-nosed, and I'm congratulations on your flexibility.
Okay. All right. Is there any, great job, guys, putting this together. Is there any further discussion on, was it 4.3?
4.4.
4.4, I'm sorry. Do I hear a motion?
Roll call.
Yeah. Is there a motion?
I think
This
Paul
Michael.
made the motion. We need a second.
I'll second it. This
Michael.
is Justice Masiwala.
Thank you. Thank you. Devin, please call the roll.
Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Kareem Gangora,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn,
Yes.
Justice Masiwala,
Yes.
Bethany Peak,
Yes.
Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Alex Chan. With 13 yeses and 0 nos, the motion passes.
Thank you. 4.5, Natalie?
Thank you. Paul, would you like to make any opening remark before I present the presentation you gave me? No? Okay. Okay, this is in regard to Oak Brook College of Law and Government Policy. This is a registered unaccredited correspondence law school located in Fresno, California. It's one of 2 law schools in the State Bar's portfolio in the Valley. And it has been generally consistently for a long time the top performing unaccredited law school in terms of bar passage rate. That continues to this day. Its cumulative pass rate is over 75% for the 5-year cumulative pass rate. This inspection is a standard 5-year periodic inspection. I'd like to thank the team of Rocco Lamana, Ellie Sheffy, and Teresa Solinsky for their virtual visit to the school. The findings are attached. What's different in this particular inspection versus prior is that the law school is thinking about the strategy for its future. It had a particular partner in the past. It has split from that partner, and it's beyond the point of graduating classes that were created through that partnership. And as a result, the law school has for a period of time been taking a moment to think very thoughtfully about how it will continue in the future, whether it will operate as it has done in the past, whether it will consider a sale, or whether it will consider accreditation. As part of that, in 2021, it did not enroll a class. Nope, in 2021 it did, 2022 it didn't, 2023 it did. So there's been some variability in this current year. The school is not specifically recruiting a class. Instead, they are collecting statements of interest, and later in the year they will decide whether to continue. As a result of that, the inspection, while the results are strong, notices several things. The first is wanting to have the committee be aware of the law school strategy in the future. The second is to note that while the attrition has been very good, while the pass rates have been excellent, in recent times there has been an increase in the attrition and some concern about the pass rate as well. The school raises a point that I'd like to share with you, so it's understood by the committee. They report in the same manner that all of the rest of the schools do, but this school, historically until this year, has taken a step in terms of the school's progression that sometimes have 1L students show up more than once in the data. After completing the first year, they sit out enrolling until they've passed the first year law students exam. Once they pass, they can roll in the next class, and that class would begin in January. So that's a unique structure that's different than any other. So we use the attrition rate that would be in our normal annual report structure. They pointed out that some of the students that we listed as attriting did indeed attrite, but they might be from more than one class. So in the staff report, we gave more detail as to that. But you can see, for example, not the most recent class, but the one prior, 8 of 9 are no longer in the class. The most recent, they still have another opportunity to take the bar exams. I'm sorry, to take the first year law students exams, so time will tell. Regarding the future operations, the school is extremely committed to its students. It does some special things that it doesn't need to do as a correspondence school, though it is correspondence and everything can be done remotely. They do have a week conference at the beginning of the year to help students become acquainted for networking purposes and also to prepare them to excel in the program. And that's something that's quite different than other schools. They also have a significant research project that they must complete before graduating, and that's unique in a number of ways. Many of the ABA schools have a journal. The school doesn't have a journal, but this is the closest approximation that we have in the unaccredited portfolio. The school, while it hasn't decided what its future will hold, says that it has verbally promised and also in its response promised that if it does take another class, it will only do so if it has the resources to continue its streak of excellence that it has enjoyed in the past. It did share what its reserves are as well, and that would be consistent with their past behavior. But with that said, though, it is important for the committee to understand if the school is in fact operating, and one of the ways that the committee does regulate and monitor the school is looking at their current operation, and it typically has not allowed an approval to continue when a school is not actively teaching classes. So this school is right now actively teaching classes, but may not be in the coming years. As with the prior item, we do have Dean Robert Barth here with us, and at this time, I'd like to recognize Dean Barth and to thank his team for their cooperation, their professionalism, and their quick response during the inspection. And when you're ready, we'll recognize you for up to 5 minutes.
Thank you very much. Can you all hear me?
Yes.
Oh, wonderful. Well, I really appreciate this opportunity to respond and also just make a few comments and a few updates. Thank you, Natalie, and also Teresa for your excellent help over this process. I've been associated with the school since its very beginning, so that's 30 years. And we've always tried to do things with excellence. We've tried to comply with all the guidelines and rules as best we can, and we certainly will do that in the future. A couple of things were raised in this particular inspection that we never had raised before, but one of the things that has come up is the attrition rate. And while noted in the actual report, the attrition rate is consistent with other schools, nonetheless, it's always been a concern of ours because we want to make sure that students who enroll actually do complete the process and go on to take and successfully pass the bar exam. With correspondence schools or distance learning schools, of course, there's always people who drop out for a variety of reasons. And that's why the attrition rate is typically a little higher, because we've got working people, family matters, and so forth, because it's a part-time school, so sometimes people drop out because of life circumstances. But we do have always concerned ourselves with the attrition rate. And as Natalie mentioned, that we do have a unique situation where we typically do not allow a student to continue into the second year until they have passed the first-year law student exam. We have made an exception on that in January of this year, and of the 8 students who completed their first year in August of 2024, 6 of those students are actually, yes, I believe 6 of those. We have 6 students in the who actually are enrolled in their second year at this time. One of the issues that's always come up, and it's actually come up from the last site visit in 2019, was just how do we define attrition? How do we define first-year students? And the way the current rules are, a first-year student could actually be still considered a first-year student for over a year after they completed their first year, if they have not taken and passed the first-year law student exam. But we will work with those rules. One of the things I noticed that in the report from the site committee, that they didn't actually look at all 5 years that we put in our self-study. And I could just reference the committee to our response on page 4 and 5, where we actually talk about the first-year law student exam pass rates over the 5 administrations from October 2019 through October 2023. And then also the bar passage rate from July 2019 through July of 2023, and February 2024, which were the dates that were available at the time we did our site study. Just a couple updates. We have opened applications. One of the measures we did to try to, if you will, help select individuals was this interest form to really qualify people. First of all, whether they were really interested, whether they were qualified initially at all before they went through the application process. We have opened up applications and are receiving applications now, so that's an update since January. And so we have opened up the applications and are anxious to see how many qualified individuals that we receive applications from. Also, as I mentioned, there are some students that were in the 2023 class who carried over and who finished their first year in 2024, August of 2024, but yet have not taken or passed the bar exam. So there's a couple students that are still in limbo as to whether they will continue on in their first year or their second year. And so they're still considered part of the first year class. I really want to appreciate the flexibility that the site inspectors gave us and the bar staff, because we had to break up our site inspection because of a litigation schedule that I had, but it worked out well. I appreciate it. I agree and thank you for the recommendation from the staff. The only request that I have and the school has is that while we are going to keep the bar very, very informed of our progress here, including how things progress as to what kind of class we have in 2025. I just ask that the normal 5-year inspection period would continue and that we would have an inspection in 5 years, which would be 2029, I believe. So that's my request.
Thank you, Dean Barth.
Are there any further questions on this? There's a resolution. You want to put it up?
Sure, I'm happy to do that. Just give me a quick moment.
Natalie, I can pull it up too. Oh,
There we go. Are we seeing my screen?
yes.
Okay, thank you.
Mr. Chair, it might be good for Natalie to speak briefly to the request to extend the time for the inspection.
Natalie?
Sure, I'd be happy to do that. When this recommendation was made, the most typical recommendation is a 5-year period. Here, the reason that a 2-year period was expected was because the school has been in a strategy hold for a period of time. I found out along with you that admissions have been opened for the fall. This is something that we were unaware of even in speaking with the school to prepare for this meeting. So we are unclear as to how things are going forward. And generally in this case, we don't do the full 5 years so that if another school is coming into the picture, we will know if the school is winding down its operations, which often comes with a reduction in the resources or a reduction in performance, the committee can know or can monitor or prevent such an outcome. So it would be consistent for staff to provide a 2-year recommendation in the circumstance. But this is a topic for your discretion and your discussion. It is something that we briefed your Ed Standards Chair, Paul Kramer, and Vice Chair Vince Reyes on previously. And if they have thoughts or questions, or the committee does, we'd be happy to entertain them.
Does anybody have a recommendation that it go to 5 years? Okay. All right. Is there any other discussion on this? Do I hear a motion?
This is Michael. I'll make the motion.
Second.
Okay. It's been moved and seconded. Devin, can you call the roll, please?
Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Kareem Gangora,
Yes.
Larry Kaplan, Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn,
Yes.
Justice Masiwala,
Yes.
Bethany Peak,
Yes.
Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Alex Chan. With 13 yeses and 0 nos, the motion passes.
Director's report?
That's my,
Yeah, Amy's got all the items. Yeah.
5.1, Amy?
yes, thank you. Good afternoon. Excuse me. I have a PowerPoint that Devin will put up. I have updates on 3 separate issues for the committee today. Starting with the first year law student exam, our June 2025 exam. Just wanted to update the committee that the exam application will open early next week. The exam date is June 24, 2025. The exam will be administered via the Psychometric platform. The State Bar has been using this platform over the past 6 exam cycles, so it's not a new system for our applicants. The primary mode is in person, so applicants can select test sites that are closest to them. They are spread all over California. We also have some test sites out of state that applicants have sat at test sites for. Applicants that do not have adequate testing space at home, or have transportation issues, or do not reside close to a Psychometric test center, have the option to test remotely. Again, just to remind everybody, the format of the exam is 100 multiple choice questions, and they're administered in 2 90-minute sessions with a 20-minute break between both of those sessions.
Okay.
All right. Oh, sorry. The next item, sorry, just 2 more updates. One is a continuation, just an update on the content validation panel. Here, I just want to highlight the work that we did in 2024. So just to be clear, all of the questions were validated by a panel. These are all the Kaplan questions, comprised of academic support professionals, specifically faculty that are familiar with bar exam material was the target, attorneys supervising entry-level attorneys, and newly licensed attorneys. The review process also included a very experienced EDGE team member. So all multiple choice questions tested over 5 2-day sessions in 2024. Those were conducted between September through December 2024. And we plan to continue the same process this year. We already held one session in February, a 2-day session. Our next one is on March next week. We have 2 more following that, April and May, which puts us on target for our July 2025 California bar exam. And last update here is on the standard validation panel. I want to remind the CBA why a standard validation is required. We need to evaluate the passing score, given that we've switched vendors for the multiple choice questions, excuse me. And that some preliminary steps that we've already completed as part of this analysis is we've confirmed the content map, drafted questions around those blueprints, constructed questions and that were validated by panel, and the exam was constructed to match the content map proportions. The exam was administered and analysis has started. And that analysis involves reviewing the questions that were on the February 2025 bar exam. We completed the first portion of this review in early March with the panel. And we will continue in April with a second panel. The data coming from those 2 sessions will come to the committee on April 18th, where we will meet and discuss the assessment of the raw passing score. Are there any questions about any of those updates?
Not a question, but Amy, can you hear me? Sorry.
Yes, I can hear.
At the April meeting, and I know this came up in public comment, the Committee of Bar Examiners is also going to consider the scoring adjustment from the experiment as part of this discussion of the February 2025 California Bar Exam and the standard validation.
All right. Amy, thank you very much and feel better. Go home.
Thank you.
Want to get some tea and lemon. All right. I think that's it for our open session agenda for today. So we're going to go in the closed session. Members and staff, please leave the open session and open the closed session per the link that was previously sent to you by Audrey. It was sent, there was an email on January 31st, 2025.
Don't use that one. Use the one that I sent you this morning.
That's what I thought.
Sorry.
Audrey, come on. I'm new at this, come on.
All right, you're good.
So everybody, we're leaving closed session and we'll be back in a moment. We're leaving open session and we'll be back in closed in just a moment.
Devon's between floors if you're waiting on her.
We're waiting for the Los Angeles conference room to come back online.
All right, sorry about that, folks. We're back in open session, seeing no further business. This meeting is adjourned, and we'll see everybody in April. Thank you.
Thank you.